Thanks so much.
And we're ready to go.
Good, thanks. Good morning. This is a convening of the Massachusetts Gaming Commission. We are holding this meeting virtually, so I will do our roll call with a good morning to Commissioner O'Brien.
Good morning. I am here.
Good morning, Commissioner Hill. Oh, we couldn't quite hear you, Commissioner Hill, just so you know. And then Commissioner Skinner.
Good
I'm
morning.
here.
Okay, great. Now that was clear. Morning, Commissioner Skinner. Thank you. And good morning, Commissioner Maynard.
Good morning.
Okay, we're going to start off. Today is November 16th. It is our public meeting number 488. We're going to have an agenda setting meeting next Monday, so we will convene again before the holiday. But I did want to note that this is the month of gratitude, and I want to give us a special thank you to the entire team for its commitment to excellence, and to all of you who honor and respect the roles and responsibilities of your fellow colleagues, and of course of the commissioners. We are very thankful. In particular, I want to give a nod to our HR team under the leadership of our Chief People and Diversity Officer, Dave Muldrew. They are working hard to make sure that we have a culture that always expresses its gratitude. And yesterday, there was a good example of that as we had a Thanksgiving celebration. And so a special shout out to Annie Missouri, who brings lots of sunlight and a big smile with all the work that she does. And it's those efforts that really, oh, there goes Katrina with the hands up, who that makes working as a commission and as an agency, even though we do it virtually a lot in hybrid nature, it's really, really special when we can all get together like we did yesterday. So thanks to Dave and team, we really appreciate it. A second note that I wanted to make to really for the benefit of the public, as opposed to the last, was really a benefit for all of us internally. I think each commissioner is reminded pretty regularly that we have stood up a regulatory framework that's demanding on our licensees, but it clearly is aligned with the values that have guided us since August 1st of 2022. And we prioritize integrity and consumer protections and, of course, responsible gaming. And with that comes a burden for our licensees, and they are working every day to comply with those regulations that demand that commitment to those values. And they're responsive and they cooperate. With that, we also have an unregulated market that doesn't provide those consumer protections to individuals in Massachusetts. And if those folks are playing on an unregulated platform, they don't get any of the benefits on responsible gaming that we've worked so hard to cultivate and enforce. They don't get the benefits of the consumer protections, and they don't get the benefits of the regulated market that each operator is providing. Insurance around their bets being honored and being their wallets being preserved, the cybersecurity that they all provide. And so this is a day to give a little gratitude for the legislature for providing a legalized market under 23N. For all of you who have worked so hard to stand up that regulated industry, and for the operators that are licensed in Massachusetts who are working hard to fulfill the vision of the law and our expectations. So just a reminder to folks, our sports books are of course located in the Encore, Boston Harbor, MGM Springfield, and Plainridge Park Casino facilities. And those are the retail, and they are fully licensed. You can place a bet in person and you can get help at the windows to understand your bets. with each casino, they're permitted to have two what we call tethered licenses. Of the three licenses, two have two tethered online operators and partners, and one has one. So BetMGM is at MGM Springfield, Caesars Sportsbook, and WinBet are at Encore Boston Harbor. Fanatics Betting and Gaming and Penn Sports Interactive are with Plainridge Park Casino. Those are the online, those are the platforms that are licensed through our casinos. Again, BetMGM, Caesars, Fanatics, PSI, now branded as ESPN Bet, and WinBet. Those are legal platforms. And then we have 5 that are independent online licensees, 3 of which are operating now. And that is Better, DraftKings, and FanDuel. Those are 3 legal platforms. So if you have a loved one who's betting on something other than the ones that are on our website, under our sports betting page, they're listed clearly with some explanation. They're betting on something that is illegal and doesn't provide the protections that we're working so hard to give. So just a reminder, and I think a healthy reminder as we move into the future. So thanks, everyone. We have a big...
Madam Chair, before you move on, I just want to, based on that comment, if I forget, if you could remind me during commissioners' updates to bring something up that circles back to what you just talked about.
Okay, excellent. Everybody make a note of that. It's a long day.
Yeah.
Thanks, Commissioner O'Brien. All right. So again, we're starting public meeting number 488, and we're going to turn now to the business at hand. Thanks for the time and our minutes. Commissioner Maynard.
Thank you, Madam Chair. And speaking of long days, these 3 meetings were long days, so I didn't know if the group wants to take them separately, if they want to put them together.
Madam Chair and Commissioner Maynard, I have just a slight edit to the March 2nd minutes. So if we need to address that by taking a vote on these individually, then we can do that. Otherwise,
Let's do them separately.
Okay.
I think let's do that, Commissioner Maynard. Good idea.
All right, thank you. Madam Chair, I move that the commission approve the minutes from the February 28th, 2023 public meeting that are included in the commissioner's packet, subject to any necessary corrections for typographical errors or other non-material matters.
second.
Thanks, Commissioner Skinner. Okay, any edits? Minor, big? Okay. Commissioner
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
Commissioner Maynard.
Aye.
Vote yes, 5-0. Thanks.
All right, thank you, Madam Chair. I move that the commission approve the minutes from the March 1st, 2023 public meeting that are included in the commissioner's packet, subject to any necessary corrections for typographical errors or other non-material matters.
Second.
Okay, are there edits?
Is this the one where Commissioner Skinner has edits or?
March
No.
2nd.
Okay. So on that, I just have a couple on the remaining, this one and the next one, but they're really typographical. So Commissioner Maynard, I can just circle back to you once it's just missing words or things that aren't supposed to be there. Nothing substantive.
All right, thank you, Commissioner O'Brien. Happy to address that.
Okay, any precise edits that you want to share? All right, Commissioner.
Oh, it was just, yeah. Aye. No. Aye. I'm
I
good.
think I understand, but it's always subject to a typo, and we do appreciate when people catch those, so thank you. Commissioner O'Brien has voted yes. Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
And Commissioner Maynard.
Aye.
And I vote yes, so 5-0 on that, subject to those changes. Thank you.
And Madam Chair, I move finally that the commission approve the minutes from the March 2nd, 2023 public meeting that are included in the commissioner's packet, subject to any necessary corrections for typographical errors or other non-material matters.
So I'll jump in now. On page 31 of the packets, page 2 of the set. Second paragraph from the bottom, I believe that comment is attributed to me and it shouldn't be.
I saw that, is that the one where it says he rather than she?
Yeah. And a
And I'm
couple,
guessing that might be Commissioner Hill. Do you have a memory of that, Commissioner Hill? It said, Commissioner someone stated that his opinion has not changed since the prior meeting, that he would prefer a waiver for both forms of agreement. And if I went back and looked at the earlier ones, it seems like that would be consistent with you. Should we?
So
do you-
I don't know how I missed that when I was reading the minutes, but I did, but that was me.
That's you, and that's you, everybody else's. Look at Judy's pine. Just
Morning. I didn't fix that one right away. So sorry.
okay. So we're in agreement that that was Commissioner Hill. Everyone.
Yeah, at that point, Commissioner Hill, my brain read that as Commissioner Hill stated that his opinion when I read it. So good catch.
I apologize.
I had seen that as well, Commissioner Skinner. Thank you for raising it. Is there anything else?
that's it for me.
Okay, so with that, Commissioner Maynard, do you want to withdraw your do we need to withdraw your motion or just say subject to, or could I have a friendly amendment? What do we do here?
Can we have a friendly amendment?
Commissioner Skinner, could you move for the amendment to change your last name?
Sure. I move to change Commissioner Skinner in the second to last paragraph at the top, the first sentence, actually, second to last paragraph of page 2 of the March 2nd, 2023 minutes to Commissioner Hill.
To read instead, Commissioner Hill. Thank you so much. Do I have a second with that friendly amendment?
Second.
Thank you, Commissioner Hill. All right. Any further discussion on this set of minutes? They did remind us of that very, very busy time, and we appreciate those minutes. They're complex. Thank you very much. Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
Commissioner Maynard.
Aye.
And I vote yes, 5-0. Okay, excellent.
Thank you, Judy.
Thanks. Thank you, Judy. I'm going to move right into the administrative update. Good morning, Todd.
Good morning, Madam Chair. Good morning, Commissioners, and to our whole team and all who are joining us here today. I'll jump right in. As we know, of course, any organization that's active in the digital world needs an information security plan. We are such an organization. In fact, of course, we are required by law to have such a plan. And we do and have for many years. And our plan itself, which is overseen by our Chief Information Officer, was recently updated. So we're here today to make you aware of the status of the Commission's ISP. To do that, I'll turn to our Chief Information Officer, Katrina Jagrib-Gomes, and our Information and Network Security Manager, Kevin Gavreau, to discuss this. Just one note before doing so, of course, some of the information in our plans is sensitive, so the documents are not being shared publicly here, and certainly there are some things that we should also not discuss in this forum. But with that as a backdrop, I'll turn things over to Kevin and to Katrina. Good morning to both of you. The floor is yours.
Good morning. Thank you, Interim Executive Director Grossman. Good morning, Madam Chair and fellow commissioners.
Good morning, Chief.
So pursuant to 201 CMR 17, which implements the provisions of MGL Chapter 93H, any entity that owns or licenses personal information about a resident of the Commonwealth of Massachusetts must establish minimum standards to be met to safeguard that personal information. As such, 201 CMR 17 requires that the Massachusetts Gaming Commission develops, implements, and maintains a comprehensive written information security program, or commonly known as WISP. These policies are similar to the submissions from our licensees that are also reviewed annually by the ITS division for compliance. We are also required by the Comptroller's Office to annually attest to having these policies in place via the internal controls questionnaire. Our intention after today is to make the policies available via the newly designed ITS intranet for access by all MGC staff. I will now hand it over to Kevin Gavro, our Information and Network Security Manager, for a deeper explanation of the information security policies.
Good morning, Madam Chair, fellow commissioners.
Good morning.
Information security policies, or ISPs, are a set of rules and procedures that ensure the Commission's digital security and protection. ISPs, in conjunction with the implementation from IT, also protect sensitive information and make sure only authorized individuals can access it. While the ISP is established and maintained by the IT team, the included rules and guidelines apply to all members of the Commission. Information security policies provide the foundation for how we build our security program. They help to provide a roadmap for how we operate the Commission's security program, and they also help to articulate that we have done the due diligence of creating a comprehensive security program. The objective of the information security policies are to enable organizational strategy for the protection of customer data and material non-public information, comply with applicable laws, regulations, contractual obligations, establish a governance structure to effectively and efficiently manage information security risk, manage identified security risks to an acceptable level through design, implementation, and maintenance risk remediation plans, establish a culture of accountability and increase the level of awareness to all personnel in order to meet information security requirements, and to establish responsibility and accountability for information security policies and governance across the Commission. We initially adopted the Executive Office of Technology, Services, and Security's Information Security Policies, also known as EOTS, which all executive agencies follow. We have since rebranded and made minor modifications to language to reflect the needs of the Commission. These policies will be updated at least annually or following any significant change to industry standards or the Commission's infrastructure using EOTS policies, the National Institute for Standard and Technology, and the Center for Internet Security as guidelines. At this time, I'll dive into a few examples of standards covered in the ISPs. Passwords. As we all know, passwords at the MGC have specific complexity requirements. Those requirements are detailed in the Access Management Standard, which focuses on account lifecycle, granting, modifying, and revoking access privileges to protect assets from unauthorized access. Typically, access privileges are provisioned using the least privilege access principle. Asset inventory. A thorough inventory through an information security classification system, which is found in the Asset Management Standard, allows ITS to better implement and standardize security controls to protect endpoints and mobile devices from malware and information leakage. Another example, security controls contained in the Physical and Environmental Security Standard manage access to information assets and facilities with safeguards to protect against environmental hazards and unauthorized access. We are open to answer any questions, or if there are none, I will hand it over to Interim Executive Director Grossman.
Questions, Commissioners, for Kevin or Chief Gomes? Kevin, I think I just want to thank you and your team for the work that you do regularly. Katrina, we rely so much on your entire team, and we also know the good work that Kevin's division is doing. These issues around cybersecurity and IT security are only getting more and more complicated, and I feel confident based on really your everyday guidance that we get that you are staying well ahead of the curve on those complexities, well educated, you're getting your training, and in turn, you're keeping us aware and trained. I just want to extend my appreciation for the training that you give us.
Thank you.
Thank you.
Okay, anything else? All right.
Thank you, Kevin and Katrina. Well done. And Madam Chair, Commissioners, that's all we have for you today.
Okay, excellent. Thank you, Todd. All right. And returning to our legal team, and that's you again, Todd, and wearing a different hat, but you've got, I see Ying is on board, and I know that Director Van der Linden will be joining. There we go. Good morning. Good morning, Ms. Wang. How are you?
Good morning, Madam Chair and Commissioners. The Legal Division is bringing forward suggested amendments to 205 CMR 152 for your review. These are amendments to the involuntary exclusion list. They specifically relate to court-ordered exclusion as set out in the statute. This is the first time you're seeing this draft, and we're going to ask you at the end if you're comfortable with moving this version through the promulgation process. So if you give me one moment, I'll pull up the statute. So before diving in, it's important to note that under Massachusetts General Law, Chapter 23K, there are three types of exclusion. There's involuntary exclusion, there's voluntary self-exclusion, and then there's a lesser known form of exclusion called court-ordered exclusion, which we're here to talk about today. This is a mechanism for an immediate family member or guardian to petition the district court in writing for an order of exclusion from gaming establishments for someone they have reason to believe is a problem gambler. We need to make sure our regulations accommodate that, and I'm prepared to walk you through the proposed changes section by section. I also wanted to note I'm joined today by Mark van der Linden, a Director of the Research and Responsible Gaming Division, and Heather Hall, Interim Director and Chief Enforcement Counsel of the IEB, who can also answer any other questions you may have about court-ordered exclusion. So if you turn to page 39 of your meeting packet, I also have it open here as well. You will find a red line version of the regulation with our proposed amendments. First, in the section titles, we propose adding the words exclusion before list in 152.02 and 152.04 for clarity purposes. We also propose changing the title to 152.05 to make it clear that this section refers to court-ordered exclusion. Then in 152.01, scope and authority, we propose adding a citation to the statute about court-ordered exclusion, which you can see here in red. Does anyone have any questions so far?
I think we're all set. Thank you.
Great. And then turning to 152.02, maintenance and distribution of exclusion list, the Commission shall maintain the list of persons to be excluded from gaming and sports wagering as set forth in this regulation, and the name and year of birth of each person on the exclusion list shall be posted on the Commission's website, except for the individuals on the court-ordered exclusion list pursuant to Massachusetts General Law, Chapter 23K, Section 45I. I think what's important to note here is that list of excluded persons is a defined term under Massachusetts General Law, Chapter 23K. So the list of individuals on the involuntary exclusion list and the court-ordered exclusion list will make up the list of excluded persons. However, we are proposing by regulation not to include the category of court-ordered exclusion individuals on the website, given that this list refers to individuals with a health issue. Does anyone have any questions about that particular section?
All set. Thanks.
And then moving down to 152.05, page 41 of your packet. We also propose amendments to 152.05 about court-ordered exclusion. This section specifies that upon receipt of a notice from a district court that an individual has been prohibited from gaming and gaming establishments, the Bureau shall place the name of the individual on the exclusion list. That same list of court-ordered exclusion shall be maintained by the Bureau and shared with the gaming licensees. And then finally, the Bureau shall not remove the name of an individual from the court-ordered exclusion list until ordered to do so by a court of competent jurisdiction.
So, Madam Chair, when I had my briefing with legal on this one. This reg only deals with what is the statutory obligation that we have as a commission and in ultimately the Bureau to act in accordance with the district court order. I did raise the question hypothetically of if we got any sort of order or request from another court, probate, a condition of probation in the criminal context. It's not this reg that would speak to that, but I did want to throw out that legal and we might want to think about how we, the commission and the Bureau, respond if there's a request outside of an order from district court, because I don't think it's the only way that may come in front of us. So that's a discussion for another day, but I did want to throw out that I'd had that conversation with legal.
Thank you. Any other comments or? Well, I want to update the commission that I reached out to the trial court administrator, Tom Ambrosino, and Commissioner Skinner reached out to a contact of hers in the district court. Of course, we're both looking at trial court. I think there is perhaps, an expanded court procedures. Perhaps you're alluding to that, Commissioner O'Brien, that certainly an individual could appeal, if their name was placed and they by a family member pursuant to the process. I think those would be procedures that the courts will deal with. Mr. Ambrosino got back to us, and Commissioner Skinner saw the response as well, that they had a chance to review this and they had no comments at this time. I indicated that we wanted to just make sure they were aware, because this is unique to Massachusetts, and Mark may want to address that. And just having our conversation today and Director Vanderlin's work in the responsible gaming space may make folks once more aware of this option. And so we wanted to make sure the courts were prepared should there be more activity. It's been reported that they know of no requests pursuant to the statutory provision at this time. Commissioner Skinner, did you want to raise anything else on that?
I just want to note that the trial court has been extremely cooperative with the commission in trying to work together on developing sort of a process by which we can be informed, we the commission, as to what steps or processes and procedures the trial court is putting into place or will put into place relative to these regulatory amendments. My contact, who is the director of court services for the trial court overall, was very responsive as well. She happened to put us in touch with the deputy court administrator for the district court, and I understand that discussions will proceed with that individual, just in terms of, again, the commission gaining an understanding as to how we can inform stakeholders about that option. So Mark, I'm sure will keep us posted on how those discussions are going.
Right. And I mentioned to you, and this is also an opportunity perhaps for her and I know that we have a full lot of attorneys to assist in this, to be able to reach out perhaps to the bar or organization so that they understand this is an option for families. Mark, and did you want to add anything?
Good morning, Chair. Good morning, Commissioners. I think our number one priority from research and responsible gaming is to just make sure that family members who want to seek relief, want to seek help for themselves and for their loved one can do so as easily as possible. And we can get them the information as clear and straightforward as possible. So I think that does require us to, work closely with the court to really understand the process, how to communicate it, how to communicate their orders to individuals that would be interested in this. This is also the work of the GPAC Addiction Services Subcommittee. This was an early priority that they identified. connecting, this type of option for exclusion with information about gambling harm as it relates to family members and other resources that may be available.
Okay. Back to you, Yang. What do you need from us today?
Yes, with that, that concludes our presentation, and I'm happy to answer any other questions you may have. And we have included a small business impact statement in your packet if you'd like to vote to begin the promulgation process.
And this is standard, not emergency, correct?
Correct.
Thanks. Commissioners, are you prepared to move? Excellent work. Thank you very much, Yang.
Certainly, I can offer a motion if you're ready for it, Madam Chair.
Thanks.
I move that the commission approve the small business impact statement in the draft of 205 CMR 152 as included in the commissioner's packet and discussed here today. And further, that staff be authorized to take the steps necessary to file the required documentation with the Secretary of the Commonwealth to begin the regulation promulgation process.
Second.
Thanks, Commissioner Maynard. All right, any further discussion on this important initiative? And we just very much appreciate Ying's leadership here. Thank you so much. Commissioner Bryant.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
Commissioner Maynard.
Aye.
And I vote yes. Thank you, 5-0. All right, we're going to now move on. Sorry, I flipped my agenda. We're going to move on next to the racing regulation. And who's leading this? Good morning, Paul.
Good morning, commissioners. So this morning we're putting 205 CMR 200 before you for an emergency vote. 205 CMR 200, as you know, governs the licensing process for racetracks, including the contents, sequencing, and review of applications and the suitability process. This was before you all in mid-October for an initial review, after which we put it out for an abbreviated public comment period. We received public comments from counsel to Bay State Racing LLC and from Paul Umbrella, the executive director of the New England Horsemen's Benevolent and Protective Association. And we're grateful for those comments. We've made a few changes in response, and that's what I'm planning to walk you through today. So the overarching theme of Bay State's comments was a concern that the racing license application review process would be rigidly centered around the October 1st date in the statute and incorporated into the regulations. That is not what we envisioned. And so where we could offer amendments that might give more clarity and comfort to applicants without creating actual logistical problems for the commission, or where we could introduce more flexibility into the process, we did. So first, Bay State Racing expressed concerns about the rigidity of the timelines for the receipt of scoping surveys, BEDs, MJPHDs, and mass subs. As a reminder, the draft regulation requires operators who need to submit those forms to attest that if they haven't gotten those, that they understand that if they haven't gotten those forms in by a certain date in the spring and summer, that it may not leave the commission enough time to adequately review the suitability of the applicant, and the commission may deny the application accordingly. Those timelines were not meant to be rigid. An applicant can always supply materials earlier. Instead, they're designed to protect the commission against the worst case scenario where the applicant waits until the last minute to provide materials for an initial suitability review and then expects the commission to move heaven and earth between October 1st and November 15th to process the application. What is slightly rigid is that the IAB needs time with the scoping survey before they can tell the applicant exactly which affiliated entities or people need to submit a BED, MJPHD, or mass sub. But we do recognize that some of those entities or people will be obvious, and it may be helpful for us and for the applicant if the applicant can start submitting paperwork for the obvious people while the IAB is still processing the scoping survey. For example, we can put in an educated guess that the CEO of a racing operation is going to have to submit an MJPHD and a mass sub. So what we did on page 53 of your packet is allow submissions for anticipated rather than designated qualifiers with the permission of the IEB, so that the IEB can still manage the process. And then on the following page of your packet, allow the tweak the sequencing of submissions provision so that with the permission of the Bureau, applicants can submit qualifier materials on a per qualifier basis rather than as a whole. Our hope is that this will encourage applicants to be proactive both in the preparation of their materials and submission of their materials and in talking to the IEB about the staging and the sequencing of their applications, and how we can make their lives easier and how they can make our lives easier. So the next change that we recommend is to 205 CMR 2035, which is going to be on page 58 of your packet. Both Bay State Racing and the NHBPA expressed concerns that, again, the timeline was rigidly organized around the October 1st statutory deadline, and the commission would not start processing applications until after October 1st. We added language to make very clear what we always envisioned, which was that the commission could start processing applications as soon as they were complete, when appropriate to do so. The last request that both Bay State and the NHBPA made that we did not accept was to set a rigid deadline upon receipt of a complete application for the processing of that application. I think both organizations asked for a 45-day timeline based on the 45 days between October 1st and November 15th. We think adopting that change would be counter to the general principles of flexibility and dealing with situations as they come that are embodied in the rest of this regulation. And there's a risk that adopting a rigid deadline could disadvantage an applicant who has a more complex application that takes longer, or could otherwise throw roadblocks and complications in the process. What that said, not adopting a rigid application processing deadline in the regulation does not mean that the commission can't do its best to accommodate the needs of particular applicants when those needs are communicated to the commission. And if Bay State Racing, as I gather from their communications, as I gather from their comment letter, is going to need to have a license in hand to meet a certain construction or financing deadline, I trust that they will communicate that timeline to the commission, and the commission can do what is appropriate with that information. So those are all of our edits to the regulation and our remaining responses to the comments. I'm happy to answer any questions on those or on any other part of the regulation.
Questions, commissioners? Can you just help me, Paul? I want to make sure that we are being responsive to that clarity that they may need to be able to put financing in place. The solution I'm hearing you say is that they can come to the commission to make that request.
Yes, I think if an applicant informs the commission well in advance that they need, they would need to have a license in hand by April 1st. I'm making up this date. I have no idea what their timing is. If they say, we need our license in hand by April 1st, the commission, the IEB, can have a conversation with the applicant about when materials would need to come in order to make that even feasible. And then, if appropriate, you five can decide to do your best to accommodate that, to accommodate that request.
So that's a conversation that the applicant would have with the Bureau.
It depends on, I think, what stage of the process they initiate that conversation at. There's a question of staging the materials required for suitability review, and there's a question of staging and reviewing the rest of the application. And I can't predict exactly how that conversation would shape out. I don't know when they're going to be able to start organizing their materials. But broadly, I think it's a conversation. Broadly, I think it's a conversation with the commission, because the commission are going to be the ultimate deciders on the license application. But because a major portion of the sequencing and staging of the application materials has to be done in conversation with the Bureau, I think the Bureau will be a party to that conversation as well.
Does our regulation say that? Not really. So, because I am very empathetic for both parties, to be clear. If it is an April 1st, they put it together, let's say December of the new year, and they need it April 1st, and they're having conversations with IEB about suitability. I know that that's a lot of work for IEB, and yet they may have a real business need. So I guess my thought would be, IEB, you don't need to bear that burden yourselves, and you should come to the commission for us to talk it through. It could be that there's a decision to provide additional resources to get that suitability study done, or we just explain that it's not reasonable. But I think it is, I could imagine, because we're operating with a 1 year window always on these, that could come up. Commissioners, I don't know if you have any thoughts on it. All set then? Any other questions for Paul? Heather, do you want to chime in?
Thank you, Chair. I don't have any thoughts on this at the moment. I know that IEB worked closely with A&K as well as our internal legal folks, so I think we're in a comfortable place with it.
Yeah, and you understand my point, I assume, where there could be a real business pressure against, and the commission could really help you if there's that point of pressure.
Absolutely, and we would keep the lines of communication flowing to the commission.
Yeah, we could come up with something. Okay. Commissioners, are you prepared to move? This is excellent work, long time coming, and so important. Really starting to provide clarity through this regulatory process. And we thank Foley Hoag and Mr. Umbrella for their comments. I have a motion.
Madam Chair,
Yes, please.
I would move that the commission approve the small business impact statement and the draft of 205 CMR 2.00 as included in the commissioner's packet and discussed here today, and further that staff be authorized to take the steps necessary to file the required documentation with the Secretary of the Commonwealth to begin the regulation promulgation process.
Is this by emergency or regular?
Emergency, I think.
Yeah, I thought it was. So can we move, and then is there separate emergency language potentially?
Maybe there could be a friendly amendment to Commissioner Hill's motion that it be done by emergency.
Thanks, Caitlin. Friendly amendment?
And that language is sufficient, right? That it be done pursuant to the emergency regulation process? Okay, so I would make that friendly amendment, Commissioner Hill.
Thank you. The record reflects that. With that amendment,
I would second.
Thank
I yield
you.
to Commissioner Skinner.
I didn't see Commissioner Skinner. Thank you. So Commissioner Skinner seconded with the friendly amendment. Oh no.
Commissioner Maynard, actually.
Oh, I'm sorry, Commissioner Maynard. Seconded.
I did the amendment. He did the second. So.
I was concentrating on your face, Commissioner O'Brien, and missed Commissioner Maynard. Thank you so much. We have a second from him, Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
Commissioner Maynard.
Aye.
I vote yes. Excellent. All right.
Madam Chair,
Yes.
I wanted to let you know, I seem to be having some intermittent connectivity issues. And so if I freeze or get disconnected, that is why, and I'll be right back on.
Okay. And Commissioner Skinner, so far, so good for us, I think. So thank you. Okay, now we're going to turn to item number 5. Our sports wagering team has really been working with our legal team, of course, on the data privacy regulation and the waivers that have been outstanding. So I'm going to turn to Director Ban, and you can make your opening statements and introduce everyone. Thank you so much.
Yeah, yes, Madam Chair, today we have 2 items before you. The first one being the data privacy waiver requests, and that will be presented by our business manager, Crystal Boschman. And the second one would be a request for void of a wager, and that will be by the interim operations manager, Andrew Steffen. We have parts of the legal team as well on the first section with Crystal. Crystal, I'll turn it over to you.
Thank you.
Morning,
Good
Crystal.
morning. Good morning. So we're returning to the discussion about the data privacy regulation, 205 CMR 257, which operators previously submitted waivers for, and the commission decided on November 17th, 2023 as a uniform waiver date. So with that date approaching tomorrow, we've received the updated waivers, the requests, and the implementation details we'd requested for operators to come into compliance with the regulation. Sorry, it's super bright in the apartment right now. The waiver requests are, they're all within the packet, and we've included a few charts that have that we compiled just to assist with providing an overview and dates at a glance. The general requests which have come in are focused on 257.02 and 257.02.5 specifically, as well as 257.03.4 and 257.05. So as such, the sports wagering team and the legal counsel have identified that it might make the most sense for us to walk through each regulation section as opposed to reviewing each waiver request from the operator. And Mina has offered to help guide us through the regulations to provide some context. In that, we can offer an overview of our analysis and some potential considerations for the commissioners on waiver timelines. Is that how you'd like to proceed?
Thank you, Crystal, for that. And that makes great sense. Just one point of procedure. We have reserved on the agenda the possibility of going into executive session. If that's the case for the public, we will return to this public session, but we will need to get started to learn if in fact that's the case. Thanks so much. Morning, Mina.
Good morning, Madam Chair and Commissioners. So as Crystal pointed out, there's a lot of overlapping requests here, and it made sense to us, I think, as you'll see as we go through, to focus on this by section, and really a couple of key issues come out as themes throughout the waiver requests, and sort of once we start talking about them. You'll see there's some that kind of flow from each other, and decisions on one waiver may affect the others. So I will just ask for your patience and certainly interrupt me if you need to, because we may be skipping back and forth a little bit between the documents more than we're typically doing. As the sort of key chart that I'm going to be working off of as a starting point, it starts on page 180 of your packet towards the end of the data privacy sections. And then we also will be spending a good amount of time at pages 83 onward, which is where the reg language is, but I'll try my best to describe the language so we're not going, we're not jumping around too much. So Without further ado, the first key section that got some requests, and I know it was a source of some questions for clarification, that was provided by the sports wagering division and the legal team, is 257.021. 257.02 is the section titled Data Use and Retention. It relates to the obligations and permissible uses of data and retention of data by the operator themselves. So we're not talking about third parties yet, just talking about the operators themselves and their employees, et cetera. The key question that came up, and this came up in the comments beforehand, and we had broadened it a bit during the rulemaking process, is the section starts with a sports wagering operator shall only use confidential information and personally identifiable information as, quote, as necessary to operate a sports wagering area, sports wagering facility, or sports wagering platform, or to comply with 23N, 205 CMR, or any other applicable law, regulation, court order, et cetera, to detect security incidents, protect against malicious behavior. There's a sort of litany of sort of legal pieces to that. Much of the questions, or many of the questions we got on the waivers had to do with what exactly necessary to operate might mean. I'm going to try to take these up into two sections. One is for data use and retention, then for sharing with third parties. The clarification that I think sports wagering provided, and that we agree with this reading, is that necessary to operate really does have a pretty broad meaning. It is everything that an operator has to do to provide the product that they're providing to patrons in a safe way, to be able to ensure that the folks who are using it are not subject to fraud, that the operator itself or the Commonwealth isn't being opened up to fraud or the use of fraudulent accounts. It certainly would include any of the anti-money laundering provisions or protections that folks have. So it is a fairly broad piece. And the reason it matters in the reg is that outside of that necessary to operate is where operators would need to seek consent for use of data. In our discussions with operators about this, it does seem to be that most of the concerns about where necessary to operate might spill into something that needs consent really actually get into the sharing with third parties, because it is hard to, it's almost, there's going to be a lot of variety and discretion from operator to operator on what's really necessary for them, depending on how they structure their platform, how they structure their operations, how they run their security apparatus, et cetera. So we think it's a fairly broad definition. It actually allows a lot of usage of data with proper protections. So given that clarification, I think some operators have phrased this, at request. Some operators have said, okay, now that we have that clarification, we're kind of good to move forward with this section. Others have asked for time to properly scope their compliance, especially in thinking about the section I'll talk about next, the consents for additional uses. The ones that are related specifically to 257.021 are a request from Fanatics to extend through May 2024, and one, it's actually three, sorry. DraftKings has asked for both 01 and 02 through July 1, 2024, and Caesars through June 30th, so effectively the same, one day apart. This is one where the commission could decide if it were inclined to grant these waivers, to grant all of them to a certain date or to grant them to the dates asked. Fanatics is suggesting it can be about a month and a half, 2 months ahead of the DraftKings and Caesars dates, but all roughly late spring, early end of spring as the dates for the waiver. And I think this is sort of to adjust for the information that came out of the process, the first waiver process that we've just gone through.
So Mina, can I ask you,
Sure.
I know that the data privacy group from the AG's office was involved in the roundtable and some of the conversations about the wording and the timing. Did we consult with them at all in terms of the reasonableness of the timing request?
I'll defer to Attorney Monahan on that. I know we have consulted, we have made them aware of they have the information on the waiver request. I'm not sure about that particular question.
Okay.
No, we did not discuss the particular deadlines in the requests.
Mina, I have to admit, I haven't reconciled all the dates.
Right.
But generally what you're saying, if we were to adopt a universal waiver, it would be mid-spring of 2024.
The date that was asked for this particular section is actually closer to late spring. Fanatics
Yeah.
was May, and DraftKings and Caesars were June 30th and July 1st. So really beginning of summer.
Yeah, thanks. I went through but did not try to do all of these things.
No, there's a lot of different dates, and that's one of the issue.
And are the other operators requesting as well? Is it these three who are asking for extension?
So, Commissioner Bryan, that question leads me to ask if I could. I would actually like to talk about 257.02 because more operators are asking about that side of the same thing, and I think they're related in an important way. So 257.02 is subparagraph 2 has to do with the patron consent, the opt-in consent. And as you heard during the comment process, there was some concern about an opt-in versus opt-out. Some of the operators, having thought about what they now understand to be necessary to operate, being broad enough, no longer feel like they need to do really any consents or very limited consents, and so they're not too particularly worried about it. The operators that have there are other operators who have asked for waivers on that deadline. And in actuality, I think that's actually the more active piece of the work that needs to be done. The first section is really about what necessary to operate means. So they're tied together. But for the outside of that necessary to operate, the consent, the folks asking for waivers and consent include Fanatics, DraftKings, and Caesars, the three that we talked about. Also FanDuel and Better. The requests for DraftKings and Caesars, they're really asking for the same date. So given what they know about necessary to operate, they want to also be able to have until June 30th and July 1st. We'll call it June 30th for this purpose, just for ease, end of June, to also be able to to put together the technology for the opt-in consents. FanDuel did not ask for a waiver from the first section. The interpretive section, they're only asking for a waiver on the consents to October 2024. And Better is asking for one through March 2024. So again, a little bit, there other operators have not asked for a waiver from that particular section. From my understanding from at least one of the conversations and reading through some of the packets, some of that is based on an assumption that they feel comfortable within their own legal departments and security departments that everything they're doing will be within the confines of necessary to operate for this purpose. The third party is a separate conversation, but for the purposes of what they use and store themselves.
I'm going to say the 1024, way outside my comfort zone. I see everyone is landing in that spring about 6 months from now for a lot of the other stuff. But for what it's worth, that October date seems like an outlier.
And the October was for
FanDuel.
Section 2, and the other one was for one, just to really understand their landscape. The first one that got us to June. But theoretically, once they understand that landscape, they're not so worried about the implementation. It's kind of a combined effort. And
Right.
any explanation for to address Commissioner O'Brien's concern of why October might be more reasonable than it seems?
Chris, I don't know if this is particular to FanDuel's request, I
I
think.
was gonna say that would be, and I think they are available if you wanted to address that question specifically to them. We had asked the operators to be available.
I'm just looking at their request. I can't remember what they, do we have it in their written request? We could pull that.
I mean, of course, none of the operators know what, at the time, knew what other operator dates were coming in, so they wouldn't necessarily address why they would take longer than someone else. So that's sort of the exact purpose we asked them to be here to address that. And I think Andrew is on, but
Yeah, and it's not so much a point of comparison. It might be unique to them, because so that's what I'm thinking. If they had raised a particular issue.
Looking at their,
it doesn't have to be a universal. We tend to like that operationally.
Madam Chair.
Yes, sorry. Commissioner Hill?
I think I'm hearing we have someone from FanDuel here. Can we ask them that question?
Yeah. Hi, Andrew. Good morning. How are you?
Good morning.
Here, the question is about the time.
Yes, I
frame
did.
for this particular. How are you?
I'm good. I'm good. Thank you very much. And I want to thank the commission for giving us the opportunity to answer the questions today related to our waiver request. So we lined it out in the text of the waiver request itself. We expect to commence development on the solution in Q4 of 2023. Our estimate that we presented was that it would take 20 to 24 weeks to develop the solution, about 4 to 6 weeks for testing of the solution, and 1 to 2 months of the rollout of the solution in order to gain release note approvals and connect the consent mechanisms with our internal systems for operational purposes. So that's the kind of timeline that we gave, which got us to around that October 1 date. We do understand that other operators have provided in their requests today that they'd be able to do it earlier. This is what we think is a reasonable timeline. And so that's where we get. I'd be more than happy to answer any specific questions that I can about each of these steps.
Thank you. Questions for Andrew? Thank you for being here today.
I appreciate the clarification on that. I'm not inclined to go out that far, given that the other players in this sort of area can do it a little, actually substantially faster. And so my question is, how does this work if what you get is a waiver consistent with them, with the other operators, and the opportunity to come in the spring if you are in fact finding that you need the other time?
Well, I think that I'd have to consult with our tech teams on that, but my gut reaction would be that we would endeavor to create the opt-in mechanism as quickly as possible. And then the question I think would be probably on the testing and rollout of the solution is that would probably be the area that would have to be truncated if necessary to get it in place in time. So the question then becomes a question of how necessarily the reliability of the solution. Have we tested the solution to our particular standards fully in a way that we feel fully confident that it's integrated and not going to be buggy when it is implemented?
Director Band, you want to weigh in on that?
Actually, if I could, Madam Chair, before we go into that, respond to that it seems to me you could shorten the schedule, give an update without necessarily truncating the reliability and the testing. And so just for what it's worth, before we move on to Director Band, I'm inclined, while I hear you guys have been in the industry longer than even some of the licensees who aren't asking for that period of time. And so I know you have a lot on your plate, but I'm just leaning toward going to that June date, obviously with the understanding you could come in the spring to say, it is in fact going to take us more time. It seems it's such an important area that I'm going out almost a year seems too far for me. And then I don't know if Bruce, if you want to chime in now.
I was actually going to make the same suggestion that Commissioner O'Brien made, is that give them the shorter time period and then have them come back and say if they've reached a solution or still need more time on it. That kind of makes sense.
Yeah, and we would appreciate that. I think that would be a fair, I think, compromise for us to go forward, with an expected date, and then come back to the commission next, end of Q1 next year, say, here's where, as per our quarterly updates that we expect to provide the commission, and say, here's where we're at, here's where we think we can get it. Have we been able to speed it up to get it by the time, or what will be done by June 1, or by July 1, whatever the date is.
Madam Chair?
Yes, Commissioner Hill?
So through you to Commissioner O'Brien, I think I heard you say June 1st. Is that satisfactory to you? It would be to me, but I want to make sure. Is that what you said?
We're looking, I think Mina was collapsing the two sections, that there's some overlap for certain operators, but that they might work for the end of June.
I think there's 3 dates, 5/24, 6/30, and 7/1 were the 3 dates that are various operators put out there as markers.
Well, there was even a March date too, right? So some might be able to be earlier.
For the O2.
Right. And of course, some haven't asked for waivers at all, so presumably they're all set.
So, Mina, what's your suggestion in terms of how best to make this helpful for the sports wagering team to monitor and enforce, and then also make sure we give the operators license to make sure that there's proper integrity?
Madam Chair, I do think there is some advantage, from what I understand from conversations with Director Band and Business Director Richmond, that there is a consistency would be helpful. So if they're not looking for different dates, obviously earlier compliance is welcome, but consistency would be helpful. So if, and because O1 and O2 are so closely tied together, it does seem to make sense that where the rubber meets the road for provision O1 is in the consents in O2, so to tie those together. And June 30th as a deadline may make sense for that reason. I think the date is more of your policy piece. I will say one thing just to be clear about is that the problem that comes up if those deadlines aren't met for an operator is not necessarily that they have to roll out untested data or untested platforms. It's if they don't get a further waiver, it would be that they couldn't use use data that requires consent for those purposes other than those necessary purposes, which again, based on the input from some of the operators that didn't ask for a waiver, could be either a null set or a very small set of uses. So that's why I'd be, just thinking that it's not a matter of asking operators to put out untested platforms. It's just making sure that they know which data they need them for.
That's right. So it feels as though we should be somewhat comforted by the fact that upon understanding more clearly what necessary to operate means, that they actually are not sharing data in a way that's not complying with our expectations right now. Is that generally, you've got a sense of that, Mina?
Generally, yes, Madam Chair. I just want to make one important edit to what you said. You said sharing data. And again, I just want to focus on using and storing. Now, when we get to sharing, I do think there's other issues because I do think there may be more concern about the practicality of how to do
It was a mistake on my part, yes.
But I understand, but that's,
But I mean, the comfort level is now seems that's a good, the exercise has been helpful in that they reviewed the landscape. That's great. Okay, so commissioners, should we, well, actually, I'm going to turn to Caitlin, who keeps us organized on these types of things. Should we, are you keeping record of each of these and then we're going to vote at the end, or how would we go about this request?
So I'm keeping track of what you're saying. So just to summarize what we've just talked about, the waivers for 257.021 and 257.022 would be through June 30th for Fanatics, DraftKings, Caesars, FanDuel, and Better. I think it could be helpful to take these up one by one as we go through, just because there's a lot.
Right, that's
but we could also wait till the end, but I think it might be helpful to do it one by one once you've settled on a timeline.
And so we would look at this as a particular single waiver with respect to 202 subsection 1 and 202 subsection 2.
Yes, that's what I would recommend.
Okay, so commissioners, if we don't have any other questions with respect to this discussion, I would call it and ask for a motion.
Madam Chair, no questions, but I would like to offer comment. I think what has been proposed in terms of the compromise is a reasonable one, and I support it. But I have a specific request to not just FanDuel, but all of the operators that we're going to be reviewing waiver requests for today, and that is to the extent possible, the expectation is that operators are adjusting their business priorities to ensure that they are meeting these deadlines in terms of the waiver expiration. Mina, I appreciate that you framed sort of the consequence of not meeting those deadlines. It put things in a little bit more context for me. So I'm supportive of what's being offered here today, as I said. Thank you.
Madam Chair, just while we were talking, I did receive a note from Better with a question to clarify that if it's appropriate, it's regarding 02. So I don't know if you would like me to wait till after the vote or perhaps talk about it now, just in case it affects anybody's thinking.
I think it would be helpful, and they've reached out.
Yeah. So the question is, what would happen to existing patrons that sign up before the implementation? Will they be considered opted in or out, or will require dedicated consent from them? As the reg is written, my interpretation of the written reg is that it would cover existing patrons, because again, we're talking about the necessary uses of the data, not the not the overall sign up. So if there are uses that perhaps have been undertaken so far that would now require consent, I think there's obviously that I would leave it to the individual operators of how they seek that consent and whether they do a separate platform for one or the other. But as I think all of us who are consumers in other contexts know, it's not unusual to get an updated privacy policy, an updated privacy request, to be told your software is now different than it might have been 5 months ago, and here's some new information we're asking you about.
Hopefully that's helpful. Commissioner O'Brien, are you prepared to move?
No, I was saying he just gave a thank you in the chat, so I'm assuming that was helpful.
I didn't see that. Excellent. Commissioner Maynard.
I do have a question just on so 257.021. FanDuel did not have an issue with that. It looks like they were requesting just 2, but yet DraftKings and Caesars had 2 different dates for 01 and 02. I'm just trying to make sure that if we use a uniform date, that we're not actually incentivizing FanDuel to not move forward with 0.021. I'm just trying to think here about how we're parsing this out. I want to make sure that we're not missing something here.
No,
'Cause it
my
sounds like everybody's
apologies.
on that.
You're right. My apologies. You're absolutely right. I should have broken that, I guess, into two different motions. So one should be for 021 and then one should be for 022. I missed that there wasn't that joint request for one of them. Sorry, this one's complicated, Commission. Apologies, but these motions are going to test us today.
I have a question for the search warrant team too. When you talk about ease for you as a unit having consistency, is it consistency within each reg, right? To say, okay, date X will apply to 021, date Y will apply to 022. Does that satisfy the consistency that you said you guys might find helpful?
See if we want to take that, Mina.
Sure, sure.
Right? Everything's so complicated.
Right.
Yeah.
Yes.
I'm of the mind of
no.
Commissioner Maynard where I want to be reasonable, but I also don't want to needlessly bump something out if we can clear it off.
Understandably, and of course we've looked at that. And I guess the answer is obviously we will do whatever you guys decide. The way that we had asked for these requests was to come in with a working plan. So that's why these dates are all over the map, because we didn't want just one uniform date. However, since they are key components to a plan, it's actually, we'd still have to figure out what we do on our end to determine compliance with that component. And by that aspect, it's really going to be level of reporting, which we had asked how they would be doing that. And we'll look into the reporting. And then, of course, working with our experts internally and externally to make sure we know how to look at this. So as some of this, in which Mina is saying, goes hand in hand, and also the decisions that are made today will impact whether they can move even quicker, perhaps. It really, I'm not sure, matters whether they're entirely different dates or they're all uniform. So there are pieces I know we're moving toward in a few minutes where they will make more sense that we have them set on a particular date or set apart from these two. I don't know, Mina, if you want to add to that, but really we can.
Sure,
I
sure.
see a chat. I'm reading a chat. Sorry.
No, I apologize. Madam Chair, I'm getting yet another operator asking a question to chat, and I would actually just invite them to, if through you, to speak to the commission. It may be more useful and more appropriate.
Alex? Is
Yes.
that Alex?
Yes.
Alex, for better?
Yes.
Good morning. How are you? Nice to see you.
Nice to see you as well. Thanks for the opportunity to speak. I did just want to point out, when we approached the waiver request, we addressed it as the rule in its entirety. So 0.2 in its entirety. I think the clarification on the necessary to operate has been very helpful. I can take that back to my team, but just wanted to be clear that what we represented on our waiver request is that we would be in compliance with the entirety of 25702 within 18 months. And what we'd spelled out was kind of how we think Fanatics is in a unique place, and that we're in a limited number of markets that don't have, we've not been subject to as wide an array of data privacy legal requirements as some of our competitors. And we're also in a moment where we're attempting to launch in the rest of the country. We're only in 5 markets currently. So had tried to spell out in our waiver request why our lead time might be a bit longer, but just wanted to clarify. It sounds like it was being represented that we had said we could comply by May of 24, and that's not what was in our waiver request.
And my apologies, because I thought it was Alex Ursa from Better. It's Alex Smith from Fanatics. I just want to make sure that we hear that's Fanatics. So that's really helpful to know.
So universal doesn't make sense necessarily then.
Well, I think this is why I asked the question around the dates, because
I feel like we're gonna have to do tranches where it's sort of we'll have a date. This is where I'm coming from. We have a date that seems to fall with most that have asked for extensions. And even Fanatics at that point would come back at that point with an update, and ideally even a more sort of informed at that point request for an extension. So if we're going to do universal, that's sort of where I'm thinking we do this, because it seems like people may be coming in as they implement with all sorts of different challenges and dates.
I think the challenge right now for me is, I think I understood Mr. Smith saying that they looked at it as a date for their entire
as opposed to pieces.
And I'm not sure if perhaps other operators did the same thing. I think there's some value in Commissioner Skinner's. There's a lot of value in Commissioner Skinner's point, is that, you know, we want the operators. They understand this is very critical to Massachusetts, and it's in their interest to get the systems going in full compliance, because this is the expectation. But I worry about if we have so many different dates for compliance on all of these separate issues, that's going to be hard for our team. And so
that's why I was thinking, do we pick one that seems to coalesce around sort of an agreed upon, at least step forward on these? And I don't know if June 30th is that date. And then we calendar this so that it comes back in front of us a good maybe 6 weeks to 2 months prior, where our team is getting updates on if anyone needs longer. Fully recognizing that you have certain licensees like Fanatics who've already indicated that they will likely be coming back at that point and asking for more time.
Yeah, I guess I'm just wondering how many are in that category. I don't know if we have a sense of that, Nina.
Yeah, so Madam Chair, the requests that came in, there were a couple of operators that covered sections more broadly. Fanatics did ask, and I apologize, I think that may have just been a mistake on the written timeline that was in front of me, that for this 18 months. So that's 20, they asked for all of 257.02, the entirety of 257.02. Other than that, Fanatics also did that with other provisions that we'll get to later, so I will try to mark those as we go. The folks at MGM Springfield asked for 257 generally, the whole reg, through May 15, 2024. So we decided to take this up in pieces first, because I think it does include this, but they were talking about the contract sections, I believe, in particular. Part of the issue here, I think that's complicating this, is the level of granularity did differ, but those were really the two major outliers that as I mentioned. The other thing that differed between requests is whether folks only asked for waivers from the kind of moving language of the statute, of the regs, excuse me, versus the standards. So what they have to do versus what the regs mean. And so you're seeing that, for instance, in the distinction between accepting what 257.01 means, what's necessary, versus implementation of actually putting the consent platforms. You'll see it again with the contracts piece on the data sharing. What I might suggest is to Commissioner O'Brien's point, having for 257.01, for the folks who did ask for that, which would include Fanatics, a June 30th deadline for 257.01 for Fanatics, DraftKings, and Caesars, who all requested at the time. Understanding Fanatics asked for more. Keeping that same deadline for now for the consents, since and adding to that FanDuel, who also had that request, and Better, who had the March 1 request, gets you to seeing if the consent platforms can be worked out. Some of the other items, if you look at Fanatics submittal, that they put under the reasons for 257.02 taking 18 months include not just the collection and management system, but for instance, building a new user experience flow for collecting consents, implementing tools and guardrails to prevent defined data elements from being used for non-essential features. It's not really clear from the letter which of those can happen before June or not, and that gives them 7 more months to get there. It sounds like there's an understanding that that may not be it because of their unique situation with other jurisdictions.
I thought better was also looking for, you mentioned this fanatic DraftKings Caesar with respect to and with respect to and standalone better, right?
I'm sorry, Madam Chair, I didn't hear the first part of that very well.
When we're looking at 01, it
Yes.
was Fanatics, DraftKings, and Caesars, and then 02, those 3 plus FanDuel and Better. I thought it included Better as well.
I did. Yeah,
Oh, I didn't
Better had
hear
asked
that.
for a March. Yeah, sorry. Better had asked till March 1, 2024.
Okay, I'm sorry. I didn't hear Better being repeated. Okay, so it sounds as though I'm not hearing that all 5 are going to be back on June 30th looking for more time. That June 30th is realistic for the collective good of those 5. The others are all set. Is that fair?
Based on the representations, as I understand them from the waivers, and yeah, and of course, the others that we didn't ask for waivers at all appear to be also.
And to, Mr. Smith, you're hearing very clearly that the commission would be receptive to your input and request for a further waiver. Mr. Urser, good morning.
Good morning, Chair. Good morning, everyone. Just a small ask from myself, if waivers will be granted, we would just prefer to have the same date if that works for everyone, include ourselves there.
Okay, excellent. So June 30 sounds like the date. Commissioners, to call the question, do we have a motion?
Madam Chair, would you like Attorney Monahan or I to state the question, and would that help?
So is it
proposed motion? Because I think we're going to need 2.
Commissioner O'Brien.
Oh, we're going to need 2. So yeah, actually, if you say that threw me. So yes, I'm going to need you to say that.
Caitlin, do you want to do the honors, or do you want?
Sure, give me a second. Okay. All right, bear with me, guys. So the motion would be, I move that in accordance with 205 CMR 202.03 subsection 2, the commission issue the following waivers as further detailed in the materials in the commissioner's packet and is discussed here today, as granting the waivers meets the requirements specified in 205 CMR 102.03 subsection 4 and is consistent with the purposes of GL chapter 23N. From the requirements outlined in 205 CMR 257.02 subsection 1 to Fanatics, DraftKings, and Caesars through June 30th, 2024. That's the first motion.
Do I have a so moved?
So moved, if we can do it that way.
Do I have a second?
Second.
All right. Any further question? Commissioner O'Brien?
Aye.
Commissioner Hill?
Aye.
Commissioner Skinner?
Aye.
Commissioner Maynard?
I hate to be the fly in the ointment here, but didn't Better just ask for the same date for both 1 and 2?
I thought they were just asking for 2.
1.
Only 2. We just did 01.
Yeah, yeah, and we just did 01, yeah.
Aye.
Can flies still be in ointments? Just wondering. And I vote yes, 5-0. We're always worried about
I never
with
doubt
animals.
Commissioner Maynard's sayings ever.
Well, I always worry about when they reference animals. I worry. Okay. All right. So we got
What scares
that.
me
Now
is
we'll
I
bring-
know all of his sayings.
I don't think you do. Just when you think you do, he's got another one.
Right. Okay, now we'll go to
Okay.
O2.
Go to the next one. All right. So the motion would be, I move that in accordance with 205 CMR 202.03 subsection 2, the commission issue the following waivers as further detailed in the materials in the commissioner's packet and is discussed here today, as granting the waivers meets the requirements specified in 205 CMR 102.03 subsection 4 and is consistent with the purposes of GL Chapter 23N. From the requirements outlined in 205 CMR 257.02 subsection 2, to Fanatics, DraftKings, Caesars, FanDuel, and Better through June 30th, 2024.
So moved.
Thank you. Just a second. Commissioner Maynard?
Commissioner O'Brien had it.
Sorry, couldn't see. Commissioner O'Brien seconded. Any further discussion? Commissioner O'Brien?
Aye.
Commissioner Hill?
Aye.
Commissioner Skinner?
Aye.
Commissioner Maynard?
Aye.
And I vote yes, 5-0. All right, let's turn to the next one.
All right. I just want to make sure we got DraftKings there. Okay. So there was one more section of, before we get to 257.03, we just have one more section for now of O2. We actually have another one coming up later. Only DraftKings requested this waiver. This is to 257.02 subsection 3. This particular section is still within the data use and retention section. This is the section that has to do with the prohibition on the use of data to promote individual bets under certain circumstances. And the reg, just to start there first, lists a number of ways in which data may not be used. So this is not about consent or no consent. It's about how the data can be used. That a sports wagering operator may not use to promote individual bets, basically based on a period of dormancy, wagers made with predicted social connections or outcomes, communications with third parties other than the operator, income, actual predicted income, medical status, other backgrounds, et cetera, information, et cetera. There were some questions that came up about this in the clarifications, including in particular what dormancy means. And I think there was some comfort after discussions with sports wagering, the operators and us, that the dormancy was never intended, I think I said this during the regs, but just to reemphasize, was never intended to mean, you signed up to receive during football season and you seem to bet only on Patriots games. So we're not going to bother you during the summer baseball season. We'll wait till the NFL starts back up, and that's when you might get a promotion. That's fine. That's not dormancy. That's sort of which products you want to engage with. The dormancy is really somebody who seems to have let their account go or made a deposit and let it go. That targeting promotions for that purpose would not be allowed. After that clarification, only DraftKings has still requested a waiver explicitly. Of course, Fanatics waiver does cover this as well, that they asked for the 18 months for all of this. The basis of DraftKings waiver requests in 03 is a suggestion that they will need additional time. They ask until 023, excuse me, is until December 1, 2024. So 13 months or 12 and a half months from now, to update internal tooling, databases, and promotional campaigns, develop employee training, et cetera, and engage in comprehensive auditing of promotional activities, and to run new geolocation-based flags. So they're saying the technology that they need to build out to ensure they're complying with this may take them till December 1, 2024.
I hear that only, I'm so sorry. I hear that only DraftKings has asked for that. Direct fan, does that?
And in fairness, Fanatics by extension to asking for the whole reg, but yes.
Oh, that's.
But Fanatics
okay.
already has through June 30th based on the last motion. Do they all have through June 30th based on the last motion on O2?
No, this is O2.
O2 too.
This is 3.
Yeah.
This is 03 on the dormancy. it does strike me that that could require a good deal of technical or to ensure compliance on that. That's a relatively unique reg, right? Across the country.
It is a unique reg in the sense of what it prohibits, or it's it's certainly more explicit about what it prohibits. It is a do not do as opposed to a you must do. So I think that is, I don't know if other entities took, I can't speak for all the other operators, but after the clarification of what dormancy means, I think several seemed worried about this issue more before that was clarified.
Got it.
I think it would certainly put, if you were to grant this waiver, it would mean that one entity, could continue to market for this way and no one else could. So it would be one you might have to figure out if you kind of sort of sponte grant to others if you're going to grant it, because they'd be the only ones allowed to do a particular kind of marketing that others could, or at least not be required to prevent it until then, right? The point is, I'm not sure if anybody's engaging in this yet or not. We're going to talk about the reporting side of this in a little bit. That's one of the other issues.
But after the clarification, the only one who persisted in asking for a waiver was DraftKings.
Correct. On this, again, specifically on this.
Specifics, yeah.
So the request does include purpose of auditing, and making sure that they're in compliance and training, all of which I know we value.
It's just too far out for me. I'm flummoxed by why they're the only ones who persisted in the request after clarification. And then the years to me would seem to be excessive even with the request. So I would need to understand more from DraftKings, what was not satisfying or still deficient in the clarification, and or why that time period. Again, I'm much more inclined to give shorter extensions with updates than going out that far on these.
I just want to thank the legal team, including Mina and Annie, for the clarifications. I thought they were very well done. So we've got somebody from FanDuel who Andrew is chiming in, but I have a hard time reading chats and looking at faces and boxes. So Andrew, why don't you come on and ask?
Hi. Yes, thank you. I just wanted to state from FanDuel's perspective is that it would have very significant commercial impacts to allow such a waiver for one operator versus
and not the others.
All operators.
Right. And it's not because the other operators missed it, right? That's really my question.
Right.
That's
mine too.
Because we don't want to set anyone up for failure. We want compliance. So that was really the genesis of my concern, not because I necessarily think it should be pushed out. There's David, good morning, David Crestwood from DraftKings. Thank you. You want to turn on your video, David? Thanks. Here we come. There we are.
All right, there we are. I can't see myself, so I wasn't sure if it was working.
We can see you.
Great. I'm not sure what the distinction is and why we're the only ones to ask for this. We scoped this with those clarifications in mind, and that did give our team peace of mind that this is something we could have accomplished immediately. As we stated in the waiver, we would likely have to build a CRM or customer relationship management system just for Massachusetts outside of our normal marketing automation process. We don't have our existing services to operate on a per jurisdiction level. And one of the things we may gather from this, and I'm just not sure because we don't know the comparison, is that our platform may operate significantly differently from other operators. It may be a platform issue. I understand that, we're not seeking a competitive advantage here. I think that maybe what would make sense here, if you're open to it, is a shorter waiver so we can talk about it in detail. We would want to discuss the particulars of our platform and program, likely in an executive session, but it would have to be an executive session without other operators present, because there's a lot of detailed proprietary information that would be required to be discussed. And then what we would want, obviously, is a significant presence of DraftKings technical personnel to make sure that we're explaining this clearly and can answer any question.
I will say we cannot guarantee an executive session on that. I'm not sure that it would meet the requirements of an executive session. I just want to be clear about that as the conversation proceeds.
The rationale being that it would be competitively disadvantageous for them to go into detail about their platform, I assume.
Right, and we don't have an exception for that in sports wagering. The 6I exception only extends as far as the application extends. So once we get into operations that aren't part of the application process, we don't have that exception anymore.
Okay.
I'm just going to pause for a second. I just want to look at something. So, Mr. Presswood, the language that is on the agenda says the commission anticipates that it may need to meet an executive session in conjunction with review of the above referenced operator waiver request according to the federal laws to discuss the deployment of security devices or strategies with respect thereto, in particular with respect to use of data for sports wagering operations. I understand why there could be confusion because there are times where the competitive disadvantage is an appropriate exemption. I don't know if you want to reflect on that, but it would be deployment of security devices or strategies, and that's Councilor Grossman, what we're limited to.
Yes, as Caitlin just mentioned, of course, there are exemptions that deal with cyber issues, which is wholly different from trade secrets or competitively sensitive information, which is limited in the case of sports wagering to just the application process. The law just does not afford the commission the same flexibility that it does on the casino side. And this is a manifestation of that issue that we've discussed in the past.
Oh, and it doesn't extend here in terms of the application. This isn't covered, as to Caitlin's point, Todd.
I mean, this is not really the application.
So I think our concern then would be discussing some of the particulars of this in this forum would put us at a significant competitive disadvantage. I mean, it's opening up our proprietary platform to the world, which is, I think, something that would be challenging for us to do. I think maybe what we could do if to extend the waiver on this provision for a short time so that we can have a more detailed conversation at the staff level, maybe get some additional clarification, come back with something that everyone is comfortable with, maybe a series of tiered waivers on particular provisions here, or some kind of status update, because complying with different parts of this may take slightly different amounts of time on additional clarification.
Commissioner O'Brien.
No, that's what I was thinking. I mean, because right now, Mr. Presswood has not, you basically don't know the answer, right, for why you came in versus the other licensees. And it could be that you don't need it. It could be that you just don't know what the details are and how to tranche out the reg in terms of there might be different dates for different parts. And so I'm also hearing about the fundamental fairness of not giving. I have two concerns with going out too far. One is the fundamental fairness to the others who are apparently complying. And then the other is just wanting the reg to be implemented as soon as possible. And so it seems to me like we need to get a short, and I would say blanket waiver because I don't want to put anyone at a disadvantage competitively, and then have DraftKings come back in very short order. And I'm talking like 30 days, 45 days to come back in and say whether you need it and if so, why, and be more specific with dates.
Yeah, I think that's what I'm asking for would be, to have those clarifying conversations and a universal waiver. Like I said, this is not about a competitive advantage for us. This is about making sure that we're able to be in compliance. And if there's something that's different about our platform than other operators, well, we don't know because we don't know what the other operators' platforms are, the way they're built. We're not working from the same playbook on that.
Right. No, Mr. DePiero, I wasn't implying you were angling to get a competitive disadvantage, that we don't want to unwittingly,
Right.
do something.
Yeah, I agree.
We would probably extend it out universally, is really what we're thinking, to be fair, to Commissioner O'Brien's point. So no, very well said, Commissioner O'Brien, thanks.
Madam Chair.
Yes.
So I'm very sympathetic to what Mr. Winchell indicated in terms of being at a competitive disadvantage. And I'm sure other operators feel the same way. I'm struggling though, the fact that we haven't gotten any other any requests from any other operator on this particular subsection indicates that everyone else is complying or will be in compliance effective tomorrow. Is that accurate? Am I understanding that in the right way? And so issuing or granting a universal waiver, Commissioner O'Brien suggested 30 days, 45 days. I mean, I think I struggle with, kind of the implication of that, in that where the majority, all but one of the operators are in compliance, they're now getting sort of an extension to continue to do exactly what we are asking them not to do, or what we've said that they cannot do under the regulation. So I want to be careful there, and I want to make sure that we do keep all of the operators on a level playing field, but I would like the date to be a very short extension, because again, everyone else is ready to move on this particular subsection. And so I'm wary about altering that at this point.
Mr. Presswood?
To be fair, I want to reiterate, we aren't the only ones. Fanatics also asked in their waiver for a 12-month period explicitly, which isn't clearly represented in the chart, but is represented in their waiver. So I don't know if they have someone who wants to discuss as well, or have an opinion, but we're not totally on an island here.
Mina, and do we on careful review is it limited to DraftKings?
As far as I can tell, I mean, there's a couple of things here. Fanatics did, I mentioned at the outset of this, that Fanatics did ask for the waiver for 18 months for this whole section. And so that would cover this, but I don't believe that they made the granular points that DraftKings has sought to make about 02, 03. Yeah, we'll stop there.
So, I mean, I was looking at the calendar in terms of dates too, and we have meetings on the 30th, December 7th, December 14th, but mindful that there's a holiday in there and there's a holiday weekend in there. So 2 weeks out would put you right after Thanksgiving. The 7th would be 3 weeks out, and the 14th would be a month from today, essentially.
Yeah, 14th, and then I think the next public meeting. And because, we would be very nimble to have a special meeting, except for the fact that the holidays can get very tricky.
What would be a reasonable amount of time? I would suggest the question be pointed to Mr. Prestwood in terms of getting the answers that he needs to be able to fully communicate with perhaps our sports wagering division as to what realistically the time frame might be for implementation of this particular subsection.
Madam Chair, before Mr. Presswood answers that, if it's okay with you, Commissioner Skinner, can I just ask one clarifying question? Because I may be stuck on this as I'm reviewing it. There is actually nothing to implement in this section. This is a prohibition. And I understand that it seems to me that the concern is that that DraftKings is stating is that they cannot guarantee that they comply with this section. And I just want to be clear about that. because we're not asking them in this section to build a single thing. We're just asking them not to target people based on these following categories. So that's a distinction I think that may have mattered to other operators as well. And I apologize, Commissioner Skinner, but just as Mr. Presswood answers, I would like to make sure we
Yeah,
understand.
and I do understand that, but just based off of Mr. Presswood's indications, there's a system that needs to be built essentially in order to comply with this subsection. And so I think the request from Commissioner O'Brien, or a statement made by Commissioner O'Brien, was that it was her impression that Mr. Presswood just didn't have the answers to some of the questions today. So my question is really around that particular piece. What is a reasonable, in your assessment, time frame for you to get back to us with some of the specific information requested by Commissioner O'Brien?
I think we could put together a meeting with staff in short order with all of the relevant folks to discuss the details of the issues here. We've done all of the scoping, so we have all of the information. We can ask additional clarifying questions, and then in those conversations provide additional detail that may provide some color, things that we're not comfortable sharing, openly in public.
So I'm sorry, so I think the dates that Commissioner O'Brien set forth, I think the earliest is November 30th.
Yeah, I think December 14th would probably be a fairer date. I would make that suggestion because Commissioner Skinner, our team, Thanksgiving is in between. So for our team to work with DraftKings, the 14th would be probably better. Does that suit you, Commissioner Skinner? I'm just thinking about
it. Does, yeah. I don't want to impose any, additional, issues for our staff. And so that's precisely why I'm asking the question, is what is reasonable? And I certainly intended to pose that same question to our internal team.
And that would
reasonable on our end.
I'll throw this out though, Mr. Presswood, is that, to Mina's point, it is a prohibition. And there's a part of me that just says, why hasn't this happened where it's kind of an edict to, your advertising promotional folks that this is how it's going to be. And then in terms of all the building that needs to happen, and I noted this, I really appreciate your focus on training and the audit, but this went into effect, a while ago. And so perhaps that's why, the others don't have the same challenge. I do understand that DraftKings and FanDuel may have more complexities. And so I think I'd love to hear that on the 14th and to understand. I hear you saying you don't want to really speak about it in the public forum. I'd love it if our legal team could work with DraftKings and FanDuel to see if there's any way to provide that level of comfort that is absolutely in compliance with the open meeting law. And then to the extent there's no avenue, then we're a little stuck. We're at a crossroad. And you provide the information that can be most compelling for our decision making. Councilor Grossman, the only thing I was thinking is that I feel as though we did look at data use and data sharing in the application, but that doesn't extend here.
No, I mean, that was information specifically shared as part of the application process. This is regulatory compliance, which I think I would view as a different creature. Sometimes there are connections that can be made. This one feels like it might be a bridge too far, and that's why we've treated it this way.
Understood. Does that help, Mr. Presswood?
So I think the broad answer to the question and what may make us different, as I mentioned, is that we don't parse any of these things by jurisdiction because no other jurisdiction imposes these kinds of requirements. And so what it requires for us is to build something specifically for Massachusetts that exempts these requirements in order to comply. I suppose the alternative would be to shut down all of our marketing across the entire platform. which I think is, would put us at a significant commercial disadvantage nationwide. And so I don't even know if we could do that, to be frank. I think, the December 14th date gives us time to find time with staff. We have a lot of this information already, but I would want our really detailed technical folks to be part of that meeting so they could discuss it more clearly. And I know who all those people are because we went through a very detailed scoping process. So I think if we could get a waiver until that time, intend to have the meeting somewhere, between now and, early December. And then so we could come back with something that either we don't request a waiver, we request a very short waiver, or, we just outline what we're able to do clearly at a future meeting. I think that would be helpful for us.
That's very helpful. And I do appreciate, I think I mentioned that this is probably a unique requirement for really within the country. Commissioner Skinner.
Yeah, Mr. Presswood, I appreciate you reiterating that. I heard you when you mentioned it the very first time, and I think it is, it is complicated. And so certainly we're not, I don't think that, we want to impede, your ability to compete in the market by suggesting that you not market in any jurisdiction. I do think it's important, though, for us to understand what is feasible in terms of solutions short of building an entirely new system. And so to our team, Crystal, Bruce, and Andrew, I don't know if it makes sense to invite our consultants, GLI, to the conversation just from the technical perspective, in terms of trying to understand if there are if there's another remedy here that can be applied so that we don't have to think about a long-term extension of this, the applicability of the regulation to just one operator or any of the operators.
Thank you for that, Commissioner Skinner. I agree that we also don't want to rebuild an entire infrastructure based on this. So, we're in the same boat there. I think, it also seems likely that maybe operators have different interpretations and understanding of the language even after the clarifications. So having those detailed conversations on our end, I think, would be helpful in narrowing the scope here.
And I also think that, as I mentioned earlier in this conversation, I know that the data privacy group in the AG's office has people there that are also very knowledgeable about implementation, et cetera. So I don't know if GLI is necessary, but I think maybe a conversation with the AG's office people might help shed some light on some of this. But to me, that date, gives a 30 days. It accommodates the realities on the ground for everyone over the next 30 days. Just a housekeeping to circle back next agenda, if we could maybe do that meeting a little earlier, because I might have a conflict later in the day. So.
Okay, I think I'm going to call the question unless there's any further clarifications needed. I'm hearing that we're going to roll this discussion over to December 14th, and we'll need a motion for that, Caitlin. Is that correct?
All right, let's go. So the motion would be, I move that in accordance with 205 CMR 202.03 subsection 2, the commission issue the following waivers as further detailed in the materials in the commissioner's packet and as discussed here today, as granting the waivers meets the requirements specified in 205 CMR 102.03 subsection 4 and is consistent with the purposes of GL Chapter 23N. From the requirements outlined in 205 CMR 257.02 subsection 3 to all sports wagering operators through December 15th, 2023.
So moved.
Thank you.
Second.
Thanks, Commissioner Skinner. Any further discussion, edits? All right, Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
Commissioner Maynard.
Aye.
I vote yes, 5-0. Thank you.
Madam Chair,
Yes.
could I have clarity around the waiver date for 257.022. Was that also June 30th? No.
Yes.
That was
021 and 022 are both June 30th.
Both June 30th for both. Yeah.
Thank you.
The second pertains to 5 entities. Do you have those 5 entities, Mr. Skinner? That pertains to
Yes, Fanatics, DraftKings, Caesars, FanDuel, Better.
Yeah. Okay. All right. So we're all set on 03.
All right. Thank you, Madam Chair. And so we will move on. If I could, the next one that actually shows up.
I just need a 5-minute break, or I can hop off briefly and come back if we're not ready.
Let's think about our timing here.
I just have to hop off, so sorry.
Oh, okay. We'll continue then. Go ahead.
Okay, sure. Madam Chair, there is a 257.025 is one of the requested waivers. However, it's kind of on a different topic. So I'm going to actually go to 257.03 and then return to 257.025, if that's okay. 257.03 is the data sharing provisions. They mirror the 257.02 data use and storage provisions, but they are about sharing that data with third parties. There were 2 questions that sort of 2 sets of questions that came up around these. The first had to do again with the definition of what's necessary, and the same issue of what exactly is necessary to operate a sports book or sports wagering platform. The second, I think, is a practical concern that because now we're talking about dealings with vendors and third parties that updating and contracts that may not have automatic update language or amendment language to reflect regulatory compliance may require some time. So there, I will want to take these together. So this is really the bulk of these are addressed at all of 257.03. Some were phrased as only looking at 257.03. 1, which is a definition of what's necessary to share. Some were phrased at only looking at 033, the contract. But I think in this case, it may actually be cleaner to treat it as the entirety of the section, because this is about coming into compliance with how folks deal with their third parties. With respect to the necessary piece, the clarification we provided earlier, I think, helped address some of the issues. Where things were still a little bit more complicated is third parties within or without a company. I think there's general understanding that a party, let's say, and I'm not, let's say an operator has a marketing affiliate relationship with, let's say, like the Hilton or Marriott hotels. And for folks who might be interested in one form of entertainment, might be interested in another, they might share that data. I think everyone seems to acknowledge and agree that that's third-party sharing that requires would require consent or opting in to be able to do that, and otherwise would be prohibited. The less clear, and I think on the sort of end of the spectrum, if you have a security vendor whose job is to help monitor your IT systems and make sure that there aren't fraud accounts being set up or that they're being flagged, and data needs to be shared with them, that's absolutely necessary. And that's sort of an obvious one. The marketing person at your, you have a marketing affiliate who is sort of solely contracted to do marketing for your operator, is necessary to operate. I think that's also clear. Where it gets a little more complicated is integrated products under the same umbrella. To go back to the umbrella issues from a couple of months ago, if you are providing a promotion, if you need to provide information, or if you want to provide the data about a patron to the marketing arm, not for the sports wagering side of Fanatics, let's say, I'll just use them as an example because it's more obvious, but for the sportswear portion, is that sharing with a third party or is that covered by O2? And I think the issue there is that I think if reading the regulation, our reading of it and our intent in drafting it was those would not be operations necessary to operate a sports book. They're sort of additional parts that may have been added to a particular company, but they're not necessary to operate the sports wagering operations, as contrasted with the marketing for the sports wagering operation itself or the security features. So that's where some of this confusion came in. Having put that information out to the operators, or as best we could in the clarifications, we had a couple of the requests, as I said, were really for different parts of O3, but they really get at the same issues. These ranged in timing. FanDuel asked, I believe, for February 1, 2024, and I certainly, if I get any of these wrong, I would appreciate correction. Fanatics had this out, I believe, at least through November 2024. Caesars in June, WinBet in October, DraftKings July 1, BetMGM February. Basically, the string of them, without going through every single one, is between February of 2024 for compliance all the way through, I think FanDuel's was the furthest out, is October 2025. And that one, to be fair, there had more to do with the contracts, updating all the contracts. They were just worried about getting, just to every single vendor and getting. So there's a lot of variety on that. There's also, just to note it, the DraftKings asked for a similar, for a waiver to December 1, 2024 of a related provision, 257.05K, which has to do with the monitoring of contracts. And I understood the rationale there to be the same as Mr. Presswood just explained, that it's sort of for the ability to have systems in place to ensure compliance as opposed to the provision itself. But again, stated broadly, compliance dates are a little bit mixed on this one. We think that there's a reason that that's the case. It's really because the nature of what's being done in-house versus through third parties really does differ from operator to operator. So we can talk about different options to deal with that. If you were looking for uniformity, this may be one where you have to do a sort of the tranches of doing it for everybody until a particular date, and then seeing where folks stand at that date, because there are going to be differences among companies.
Was there any operator that didn't ask for a waiver?
That's a good question. I don't see better on here, but I'm not sure if that was, I don't want to misspeak for somebody, but I just don't see better on the list. And that's only.
Our operation is much smaller, so for us it's much easier to be able to comply with this one.
Yeah. Thank you for that.
PSI is not on this either.
I was
Right?
just going to
PSI is
say,
also not on this.
PSI is not.
Yeah.
They're not required.
Only PSI
And better.
and better.
Mina, is this 257.03 just 1 through 3 that we're talking about? We're dealing with number 4 as a separate issue?
Yes, it's 257,
Okay.
1 through 3. Yeah, we'll deal with 4 separately. My apologies.
Okay.
Thank you.
No, I probably stepped out for that, so just wanted clarity.
1 through 3.
Yeah, so this is
the outlier is that right now, February 2024 to even December 2024. I understand correctly.
In fact, actually, all the way, there's one all the way out to October 2025 in this.
I actually wrote October 25th. October 2025. Sorry.
Yeah. So
thank you for that
like
clarification.
Varied.
My mind wasn't even thinking that year yet. Okay, and I missed that. So that would be FanDuel. Andrew?
Yes, sorry, just wanted to leave me on.
For that.
Yeah, no, thank you. It's just want to clarify, and I think Mina had started the clarification. The October 2025 date is for the contract piece only. The other pieces it was requested till February of 2024. I know, and I'll just suggest this because I happen to see this in MGM's waiver request. there could be clarification that could be provided to us. If the interpretation is that the regulation on the contract language is only for contracts entered after the effective date, we could comply much quicker. We were looking at it as getting that contract language into all of our existing contracts, which we would want that October 2025 date. As those contracts come through renewal, we would have that language added. So I guess that's the question.
Yeah, and that's the same issue for DraftKings. Is that what you said, Mina? That their December date is maybe based on the same issue as FanDuel?
They went a little, they raise a slightly different point, which is the sort of the monitoring technology to be able to get all of that from what's shared as well. So, but yes, I think they also, a lot of folks raised that particular issue. And so that certainly, is a question of, I think it's just a logistical question of how soon can somebody get a contract reopened, and if they were trying to, or when contracts come up for, or if we're only asking for this for contracts as they come up for renewal, new contracts, etc.
So what do we do to address Andrew's question based on his viewing of that MGM's? Oh no, I think it was MGM's trade.
Yeah. I think there's a policy question for the commission, Madam Chair, and I could sort of phrase the two sides of it if I could. One is I understand certainly the concern from operators that it does take two to tango on a contract, right? Folks may or may not agree to it. And so some reasonable time period to at least try to address that is there. To state the argument on the other side, not saying I advocate one or the other. This is certainly a highly regulated industry, and from day one has been highly regulated. And what the reg requires is that before data is shared, that there are agreements in place about how data is protected. And in other contexts, it's not an addendum to a contract to say, now that we are sharing this data, or that this new regulatory requirement came in, we have to comply with it before we share additional data. So if the commission could take that view as well, and I think both are reasonable. One sort of intermediate between the two may be to make clear, to give some time period that's less than the full year or longer, to perhaps consistent with the consent deadline, to keep those on the same track, the June 30th deadline, and have calendared a time to talk about how this process is going with other vendors and so on. And then the commission, in the meantime, if you want, we could consider if the reg itself needs updating to exempt. You could exempt it in two different ways. I think exempting full contracts runs a risk of, if I've signed a 5-year contract on the day that the operators got their license, which was, I think by all accounts before this reg was really germinating, but it was contemplated there might be more regs coming, then you might be exempting too much, but you could apply it to data shared after the date of the reg itself. And so it's really about when the data is shared and how it's protected, as opposed to when the contract is signed, and that gives folks an ability to try to change practices over time. Again, we want to be flexible and understand that there are third parties out there. This is not entirely in the operator's control, but this, a lot of, in the comment process, the flip side of that, in the comment process, a lot of mention was made of potential statewide data privacy regulations, and I think you'd be encountering the same problem there. So, and I think the other question is sort of the specificity. If the language, where I think a lot of operators probably already have data security language in their contracts, and it's maybe making sure that it aligns or is sufficient under the reg that we have, maybe the other challenge.
We have before I turn to Mr. Michelle FanDuel, we do have comments coming in from MGM through our chat, and still have it part of the public discussion. So for that MGM, do we have somebody who can chime in? Thank you. How are you, Alexis? Nice to see you.
Thank you, Chair. My guess is that most of the operators are already operating with data protection addendums, data privacy addendums, security addendums, pieces in our contracts where we share data that cover the same themes that you've asked for, that we require information security standards. We require, that operators or that our vendors not use the data in ways that I think you guys would agree are things that are outside the scope of a normal use. But what we don't have are some of the specifics that you've asked for. And I put one in the chat. One is that employee training include criminal and civil penalties. I'm happy to put that in our data privacy addendum going forward. I don't disagree that it's a good practice to have that in there, but to go back to our vendors, maybe who do small things or do things nationwide and say, hey, we need to negotiate for these little things that only apply to eight to 10 operators. I think it would be like a disproportionate impact based on what's already in our addendums. And I speak on behalf of BetMGM, obviously, but I've been outside counsel negotiating these. And the themes are the same as in other privacy laws. So based on added value, for me, it would be best if this could be any contract sort of going forward. And we have put it in our addendum so that it will be negotiated going forward, but sort of going back and trying to revisit having vendors who maybe won't engage with us on with the same power that we would have if we were saying, hey, listen, this is it. We're going to negotiate with you or we'll go to another vendor. If it's an ongoing relationship, I'm not sure that it would be very easy for us to sort of say, never mind, we can't use you anymore in the middle of our, year or 2 year commitment.
Thank you, Andrew.
Hi, yes, just following on to that, we have the same opinion, is that, our existing contracts do have language related to data security, but they might not have the exact provisions, because in 3, in this section, there's a lot of specific language that needs to be addressed in the contract. And so each individual contract that we have previously entered into might not have everything covered that is listed out in this subsection. And so that's what our concern is, and echo the concern that Alexis brought forward, that not all vendors that we work with are the same, and the amount of leverage that we have to force someone to the negotiating table for a state-specific requirement may be different for small certain vendors, but for heavily integrated tech vendors that we have across all our platforms, it may take longer, or they may not want to address these until the contract is up for renegotiation.
Andrew and Alexis, what would be a narrow solution rather than just a late date? I mean, is there something you can help us with?
So I think what it would be and I'll defer to Alexis to weigh in on her behalf, but I think her language from their waiver, where it would be, we get the waiver until X date, or short time frame maybe, and then anything entered into after that date would have to have to address all the items in this section.
So I have a question in terms of that. My concern with only doing that is you could go years without actually getting full compliance with the intent of the reg. And you have at least 2 operators who are fully compliant apparently right now. And I would assume there's portions of these contracts that talks about regulatory compliance and the need to go back with some of these vendors. And so I don't know if it's such a hard and fast, we can't negotiate. And is it more, this is the reg change, we've been given till X, we have to go forward. So the idea of, I was going to ask Todd Grossman this too, and Caitlin, is, can the waivers, we can condition the waivers to say, you can have this time period, however, efforts have to be made to amend, like not giving you this blanket, okay, just when it's renewed, go ahead and renew it, but actually making the efforts to go back and look at these, because it could be that, I'm assuming there's also sort of addendum language or language in there that talks about we have to be compliant. And if a reg came in and this weren't just Massachusetts, I'm assuming there's language in those contracts that it would allow you to say, we have to do this because we're not compliant anymore otherwise. So I have a little more questions about a waiver being short-term, but then also language in terms of efforts made to make sure this is implemented sooner than just when it comes up for renewal.
Alexis?
I think that's absolutely fair, Commissioner. I think I suggested sort of a phase in any new contracts starting tomorrow have to, like any contracts that are initiated, not something not in the middle of a contract that's like ready for signature. And any new contract uses the template. You know, there might be you might want to think most of our contracts may be up for renewal in a year. So, you know, a year, and then, and then by February, even if a contract is being negotiated for 6 months, if it's not going to get signed until February, it has to be in there. And we'll certainly make efforts to update contracts that are ongoing that aren't going to create massive problems for our business that like needs to run things. We can do that. And then maybe something that would not be it would still be a significant amount of work, but if you say maybe a year, and then everything would include this specific language. But I do want to make sure, you know, this is very important to us, and this is not, we just do feel that the language we have covers the themes. So we don't feel like our vendor contract is deficient in that there doesn't need to be training. This is really more clarification. So we can, I think probably if we can ask for the end of next year, if the contract is not going to get renewed, if it's not up to renewal, then we have to make that additional effort. Or if it's going to automatically renew, we have to make that additional effort so that by the end of the next calendar year, any contract that touches Massachusetts should have this specific language in it.
Yeah, I don't love the really long dates. I was envisioning something more like you guys come back to have a better sense of the scope of the problem in terms of, and problem, I say in terms of scope of the task, right? In terms of how many of these are really still out there for you guys to be negotiated.
And
opposed to sort of blank it out for 13, 14 months.
Yeah, my apology. I just wanted to come in and clearly point out that in agreement with Alexis that we do believe we're generally on the themes covered in our contracts right now. And I'd like to point out in 257.03 sub 2, which I don't believe we're not requesting to the same level be waived. There's a requirement that if we are sharing the PII with a third party, that we have to engage in commercially reasonable procedures to protect the confidentiality of that information. We are not asking for a waiver from protecting the confidentiality of information that we share with a third party. We're solely asking for the waiver that the contract language that is specifically identified in 257.03.3, that we have an extended period of time to have that specific language appended to contracts.
Okay, so maybe and this is to our team, is that very particularized language that Mr. Winchell just stated, is that something, because that's a much more narrow waiver request than sort of don't make the reg section apply.
Well, I thought that's right.
Yeah.
A little reference, DraftKings also talked about sort of that technical compliance too in a different subsection, but before we go to Mina, is your request better than what Andy did?
I think my request is aligned with what Andrew said. We are using commercially reasonable efforts to protect data that we did not ask for a waiver on. We've only asked for a waiver of the specific language in section 3 that is different than other states have required in the past. So we use these, we require these. I work on them every single day to make sure that these commercially reasonable efforts are here. Generally not that difficult to negotiate because our vendors are very familiar with privacy laws at this point. This would be just I think I put in the chat an example. You know, everyone has employee training on privacy. That's a very normal thing. You guys have asked that the employee training include criminal and civil penalties. So now I have to go to a vendor and say, your employee training, you might have to change. And that's a bigger lift, especially if we're going back in time to look at older vendors to try to deal with those things. So we're taking commercially reasonable, we're making them take these steps already. And we don't treat Massachusetts data differently than we treat Colorado data or Virginia data. We don't say, oh, never mind, you don't have to care about the data or protect the data because it's Massachusetts patrons. We're relatively universal in our contracts that all the protections need to apply to all the data they get, regardless of what state the patron's from.
Mina?
Yeah, no, I appreciate that explanation from Alexis. I think I'm hearing a couple of different things that may be helpful. It really does seem to be that the concern is around the language in, specificity of the language in 3. And I think just even in this conversation, there are examples of things that I can imagine an operator asking a vendor to do and a vendor balking at, and then they may have to come back to the commission. So one way you could address this, I think if you gave a reasonable time for folks to get to their contractors with a sort of commercially reasonable efforts or good faith efforts to amend, update contracts, et cetera, then the other thing that may be worth the commission considering going forward is if you want to add in a mechanism here for approving of compliance if the contract form is substantially in compliance, but there are good reasons shown not to get there. I'll use Alexis's example. I read 3B4, which is the language we're talking about, as requiring the employers to have training that makes folks aware of the civil and criminal penalties, but not to impose them themselves. However, I can see a vendor saying, this is too much, I can't do that. I don't want to give somebody legal advice, I'm not going to do it. And they're at a standstill. BetMGM could then come back to the commission, and maybe this is something that's just more like the way internal controls are handled, to say, we have them doing all of the things, we know what they're doing with the data, we know what they're doing to restrict it, but they're not agreeing to particular language in the contract, or they're telling us, their state law is not allowing them, is not going to allow them to put that in there. So that may be a way to handle that as a regulatory fix. And in the meantime, folks can kind of help us see what contract sticking points are coming up.
I see Commissioner Maynard, Commissioner Skinner, are you kind of shaking, nodding your head too? I can't tell.
I wasn't, but I am in full agreement that there needs to be a reasonable time for operators to renegotiate their contracts. So 257.033, I'm completely amenable to.
Oh, she did freeze this time. I'll turn to Commissioner Maynard. Commissioner Skinner, if you can hear, you have frozen, but I'm just in the interest of time, I'll have Commissioner Maynard chime in, and then you'll regroup. Commissioner Maynard?
I think Commissioner Skinner's back on, and
there she is.
Going where I was going.
Yeah, so I think that's a no-brainer, the 257. I'm getting a notice that it's unstable, so hope you can hear me if you can't see me. So on board with an extension for 257.033, but I think we should probably spend a little bit more time talking about 257.031, because I think that to me is a different request altogether, and it speaks to the actual sharing of the data. So I'll just say that, and I think if Commissioner Maynard wants to talk about 033, then I'll yield to him.
Let's deal with 033, because we kind of got a solution here, and I'd like to get that narrow solution in, and then we'll expand as required to make sure that the 01 and 02 are presenting issues. Okay, Commissioner Maynard.
No, I think that I like where the conversation is going on the solve and the fix. I'm always looking for the solve and the fix. I hear what Alexis is saying, which I appreciate. I've expressed it over and over again that I think the soft belly when it comes to data breaches is not through companies themselves, but through vendors and third parties where they're not as secure as the actual principals. And we see that over and over again in various examples. So I do want it to be done. I do want it to be negotiated. I think that we have the best operators in the world and that they're very smart and that they're very good negotiators when it comes to their vendors and that they're going to get it done. But I'm also, I understand why it's going to take some time to hit the contracts as they cycle through. But I really just want that check-in point, as Commissioner O'Brien has emphasized over and over, that we at least know where we are, where we're going, and where you need to go.
So we're looking at some kind of an amendment, Nina, thank you, Commissioner, for some kind of amendment that says that the operators will take all reasonable commercially reasonable steps to amend their contracts, but that to reflect the requirements in 04 subsection 3. But that entering any new contracts, they'll be needing to be fully compliant, right? Is that the
That is certainly one possibility. I think giving some time for the process to start will help us refine that a little bit more, but I agree. Yeah, that makes sense.
And so what's the time? What would be the recommended time frame for this, the immediate, which is tomorrow, and then those commercially reasonable, that isn't a time frame. That's, they're going to be engaged in it. I suppose we could have our team do some informal check-ins or audits of whatever, right? Our compliance officers.
I apologize, I may have misunderstood. If you're talking about an amendment to the waiver that they continue on that process as a condition of the waiver, then yes, that would go along with the waiver today. Let me talk about 031 for just 1 second, because I think it might help clarify the time without moving off of 033.
Okay, thank you.
Yes, I know the concern is not to.
I'm trying to move it along, thank you.
So the 031 issues are similar to the 021 issues of what does it need to be necessary to operate. And what you did there is tied the time for the consent technology to be the same as for the, making sure the scoping is right. I would actually keep, from my perspective, I think it might make sense to have all those dates kind of be together. So it's all June 30th, 2024 for 031 and 033. That actually keeps in place 032, which is the provision that Mr. Winchell mentioned. There's still a ready, have to have some commercially reasonable efforts. There are two entities, I believe, Fanatics and FanDuel, that asked for a waiver from all of 03 without distinguishing between them. I'm not sure, frankly, what to do with that, because I think this conversation, or I don't think we've reached that point in this conversation, because 02 does have substantive protections that it sounds like folks are otherwise complying with already.
Madam Chair, question for Mina.
Yes, please.
Mina, you laid out a policy decision that needs to be made relative to, I thought, both 031 and 033. Could you, if there's time and with the chair's permission, could you just review the one applicable to 031 again?
Sure. The 031, it's not so much a policy decision as just interpretation of it now, of how far necessary to operate should be interpreted. And the clarification has been given to date by in the form of the correspondence with the Sports Wagering Division and legal, is that necessary to operate does include running the business of the sportsbook, including marketing for, and I keep using sportsbook, but it's sportsbook platform, et cetera, the sports wagering operation. including the marketing and et cetera. If you need to share with a third party to conduct some ancillary business, whether that's a third party that is entirely separate, like the Marriott example I mentioned, or a affiliated entity that's part of the same organization, we would consider that third party. So that's the issue of interpretation. Commissioner Skinner, I also mentioned the policy issue of what data it applies to, whether it's all data going forward, regardless of the contract or not. 1 and 2, and I think Mr. Winchell gets at this, which don't require contract amendment, would apply to all data, whether it's been shared before or not. It's how the data is protected. It's really about the legally enforceable mechanisms that the operators can then put into place for that, and that's the contracts, and that's where 3 comes in.
Thank you. So granting the waiver extension for 257.031 would allow operators to continue to share data with third parties, even when it's not necessary to operate their business.
Correct, but they would
To the
still have to
extent that they're doing that right now.
Yeah, to the extent that they're doing that, and they would still have to take commercially reasonable measures to protect it, but they would be allowed to do it without the opt-in. That's really the other piece of this, is that the consent piece of it that's the other reason to match the consent deadline that you already provided in 02.
And the connection to the waivers that we granted earlier in this meeting, could you just review that one more time?
Sure. So the connections are that there's a similar question first with the definition of what's necessary to operate. So that's, as folks are figuring that out. There is also a connection in the fact of consent and how it's being used could end up being a way for to address some of the issues, and so that's why it might make the same deadline. I think to the point, Mr. I'm sorry, I apologize. I think it was DraftKings that was making this point. That's right. It was Dave. Yes, I'm sorry. Yeah, the point that he was making earlier, the monitoring and sort of back-end compliance would be the same for, are we getting consent the right way, and are we getting and are our our vendors, et cetera, getting consent the right way? So that's why they match up, is it's sort of all at the same time.
Mr. Smith?
Yes, just wanted to add, I think similar to DraftKings earlier, I would hesitate to get into too many details here, but as you can imagine, this might affect Fanatics in a way that doesn't hit other operators as hard. We have there are a lot of ways our business works with our affiliate businesses, and so would some of that was disclosed in our application process, both on a technological perspective and of course marketing as well. So I do think there's some layers to this for Fanatics, and would want to hesitate to get into the details of that for competitive reasons, but just wanted to raise that concern.
Mina, what is your recommendation?
My recommendation is if you're inclined to provide a waiver for a reasonable time, which it sounds like that's where the commission is to provide a waiver of 205 CMR 257.03 1 and 3. Let's start there. If we're talking about 2, 1 and 3 until June 30th, Again, subject to the condition that the commission expects operators in the case of 257.033 to take good faith, commercially reasonable efforts to amend existing contracts to come into compliance and to implement the requirements of 03 in new contracts between now and June. And that's the recommendation for what the motion would say. And then I would separately recommend, Madam Chair, that the legal team and sports wagering continue to think about whether the language of the reg could include a safety valve to address after that.
Okay, but that's what I wondered. So that could be considered along the way. Okay.
Exactly. So by the time we get to June, we might have already built something in that you don't need more waivers. They're sort of built into the process.
Yeah. Okay. Commissioners, I'm going to turn to Caitlin to see if we would be ready to move with her suggestion as to a motion to accommodate what sounds like a problem that we have solved for. It seems reasonable and fair. Caitlin, are you in that position to offer? Okay, good.
Yes.
I went slowly just to give you a couple more minutes.
I appreciate that. We'll start with 257.03 subsection 1. So the motion would be, I move that in accordance with 205 CMR 202.03 subsection 2, the commission issue the following waivers as further detailed in the materials in the commissioner's packet and as discussed here today, as granting the waivers meets the requirements specified in 205 CMR 102.03 subsection 4 and is consistent with the purposes of GL chapter 23N. From the requirements outlined in 205 CMR 257.03 subsection 1 to FanDuel, Fanatics, Caesars, WinBet, and DraftKings through June 30th, 2024.
So moved. Oh, wait a minute.
So moved, and then we can have a
Not a-
second discussion.
I'm taking my so moved back, Madam Chair, for a moment.
Okay, we've heard the proposed motion. Commissioner O'Brien?
I guess I was anticipating also having language in there. I mean,
I had that language in 033, but I could combine the motions.
so I know that it's not necessarily the contract language wouldn't necessarily be in there, but I thought the commercially reasonable efforts to comply requirement was still going to be in there.
Applies to 3, right?
I thought as to both. I thought that we were going to try to not have them sharing it for purposes other than as necessary.
I'll defer to Mina on where that language should be.
I think that might make sense, Commissioner O'Brien. 02 would already capture some of that, but I think the point is everybody is doing their best to comply with both of these between now and then, but understanding that there are implementation hiccups and that there may be some grace given during that.
Right. So I don't know if there's an objection to putting in, they will make, notwithstanding this waiver, licensees will make commercially reasonable efforts to comply with sub 1.
Yeah, I can redo that in 1 second.
My question is, I know that PSI and Better have not made this request. Can we make it universal just in the instant that they wake up tomorrow morning and say, oh, can we extend it? Is that all right? Is that fair?
Madam Chair,
move, can we do that? Or
They didn't move, but I think we've made it universal so far.
We have in the past as well, when only 1 or 2 operators have not asked, just in case they evaluate, they don't have to come in later for another waiver, which would just set them at the same point.
Yeah, after today's discussion, they may say something. Is that fair? Is that a problem, Nina?
Madam Chair, unless Caitlin has something to different on this. I think it may be a good idea and actually may simplify both of these. The other reason you may want to do that is, again, because of the different ways different legal departments, I think, approach the waivers. Not everybody who asks for an 03 waiver asks for an 01 waiver and vice versa. So since we are tying them together more closely, it may just make sense to do it as universal.
So could someone clarify, Madam Chair? I'm sorry. Could I just get clarification as why a universal waiver makes sense here, but not for instance, 257.021, 257.022, etc.
I think the distinction I would make, Commissioner Skinner, is that because this is now touching third parties and it actually has more implementation wrinkles that reach beyond the operators themselves. Many of the or what I understand, the reason that many operators who didn't ask for a waiver under 257.02, the reason they didn't ask for a waiver was because they felt like they would not need to use data in a way that went outside what's necessary. So they weren't even worried really about consent or not. They were feeling good about it. Whereas here, I think we all acknowledge that even the smallest operators or the ones that do the most in-house are going to need some third-party contact. And it may be, frankly, from my perspective, it may be less confusing for the vendor industry as well, especially if they're dealing with multiple operators, if they know that they're all under the same rule.
And that's true for 257.02 subsection 3.
03 subsection 3. Oh, so are you asking, is my point about 02, is it true for 023 as well?
Oh, is it true for, 023, yeah. That we issued to two operators.
I would advocate that, particularly for 03. We are not combining, or we are combining 01 and 03, but with respect to the contracting issue, I would suggest that while there are two that identified maybe not a need, that given third party affiliate challenges that could arise, that we just extend it to all of them. But we appreciate them not asking for a waiver, certainly, given today's discussion. Right. And then I don't know about.
I'm sorry. I think Nina was trying to answer my question. I don't.
My apologies, Commissioner Skinner. I just on process. I'm still also perplexed about the combination of 01 and 03, and if we can simplify things, I welcome it. Please.
Yeah, my question pertains specifically to 257.02 subsection 3, just in terms of universal waiver versus just to specific operators.
This is that, okay.
Yeah, Commissioner Skinner, I guess two reasons. One, very candid ones. I think at that point we hadn't evolved to this point of the conversation, but I think the real distinction is still the same, that it's not clear that all operators will need to put any consent mechanisms out there or to design them, or that because not all of them envision that they might need that feature. If that becomes something that somebody decides, they may be able to come back. But there was wider spread concern, I would say, about the contract issue that came up in 257.033 than there was in 257.022, especially after the clarifications in about 021.
Well, and I think Commissioner Skinner was also asking about 02 subsection 3, which one of the issues there was, frankly, fairness for all the operators. If one operator was allowed to continue to advertise in a way that the other operators weren't allowed to, that wouldn't be fair. And so that's why it was extended to all for a short time period.
Commissioner Skinner, my apologies. I was thinking of 02, not 03 when I answered that question. Caitlin's right. 033 was the one where you gave a 023. 257.023 is the one that, based on DraftKings comments, you gave a very limited universal extension to December to figure out something. So that is universal. So my apologies. Yeah.
So my notes are wrong because I had that only as being applicable to Fanatics and DraftKings. But so we did honor the universal waiver for that.
To your point, Commissioner Skinner, that you had raised, we were concerned about the.
All right, good. Thank you.
Okay.
Thank you.
Yeah, and so now my question, go ahead, Commissioner Maynard.
I know, I just want to point out to Mina's point, I do think that at least me and a couple other commissioners are thinking about, I don't think that it hadn't progressed to that point in the conversation. I'm trying to take a scalpel and get as much of this implemented as I possibly can. And to the operators that want to do it, I want them to do it without incentivizing, stopping. So I'm definitely thinking about each one very differently as far as should it be universal or not universal. And I think a lot of others are too.
Yeah, and so far we kind of got three options going because of that. Commissioner Maynard very well said, and that's why I paused asking, should we, put in the other two with all due respect that they did not ask for. So my question is again, the treatment of subsection 1 and subsection 3. Do we move them together? To get the good faith commercially reasonable efforts. I had thought that applied to just subsection 3. Commissioner O'Brien thought otherwise. So where are we on that?
I have it as two motions right now. I can update it so that it sounds like consensus is around them being for all sports wagering operators, but I think it'll be a little bit more clean if we do it as two. So just to preface before I read the whole thing, I have 257.031 being a waiver through June 30th, 2024 for all sports wagering operators, and notwithstanding the waiver, licensees will make all commercially reasonable efforts to comply with 205 CMR 257.031. And then separately, we'd have 257.033. That would also be a waiver through June 30th, 2024. That would be for all, I'm making my notes as I go, all sports wagering operators. 1 second. And notwithstanding the waiver, all new contracts must conform with the requirements of 205 CMR 257.033, and operators must make all commercially reasonable efforts to conform existing and ongoing contracts with 205 CMR 257.033.
I've got a question from Alexis. Thank you.
Just a request for a clarification, new contracts being newly, like we've got contracts that are in all parts of the world, right? Like we've got contracts that are ready to get signed. We've got contracts that are, have been heavily negotiated. Maybe we have one or two little things to do. And we've got contracts that are relatively new that adding new provisions now will not create issues. Could we a request that it's not new contracts that are signed? If we're going to say new contracts that are signed maybe January 1st, just to give a little time to not throw wrenches and things that are basically already done. We could still use commercially reasonable things in, but I want to just be clear about what's in the contract, I guess.
This regulation went into effect when?
September 1st. And then we've had the waiver, the blanket, all the industries had the blanket waiver until tomorrow.
Yeah. Thanks. Guidance from our legal team on this. What were you thinking when you thought of quote unquote new contracts, Mina and Caitlin?
I was thinking of, if it's signed tomorrow, it includes this, but I understand Alexis's point. So it's a policy question for the commission, whether you want it, given in light of the fact that the reg has been in place with a waiver, whether you think tomorrow is the appropriate time to start implementing this language, or whether you'd like to give a short window at which point after, I don't know, December 1st, all contracts have to, comply, something along those lines.
Mina, what are you thinking?
I agree with Caitlin on that. I think it's a little bit of a judgment call. Frankly, at the end of the day, I think this is going to be a matter more of enforcement discretion and waivers of if a commercially reasonable effort to try to get a new contract. It really depends on the vendor and whether they would pick up the phone and say, we'll add this language now or not. I just think.
I'm sorry. I guess, if you could just hold for 1 minute, Commissioner Skinner. I think I lost you though.
I'm on the phone, and I got disconnected from HD meeting. And so my question is really, when you're ready, if
Okay.
Caitlin could just repeat what she said, because I missed it in its entirety.
Oh,
Sure,
okay, so
absolutely.
that's good. And then also, if you could give us maybe like a bracketed language to address Alexis as another option. And I don't know if you're ready
Sure.
for that, Caitlin. Thanks.
Sure, I'll try. So Commissioner Skinner, what I had said is to respond to Ms. Coco's point, there are two options the commission could take. The first option would be to say, you know, the reg has been in place, albeit with a waiver for a while now. And so starting tomorrow, all new contracts need to have the language that is required. The second option would be to say, we understand that there may be some contracts that are close to finalization and it would be harder to get that language in. So we'll say that all contracts must conform with the requirements as of a date certain, December 1st, something like that, to give a little bit of wiggle room. I think those are the two options, and then I would do the language accordingly.
So point of clarification, Ms. Coco, are you saying January 1 of 24 would suffice as a date in terms of from that date forward? So you're talking about a month, 6 weeks at most?
I think I could do that with my legal team not tar and feathering me.
I hate to say this, but there's a difference between tar and feathering, and like we just can't put the brakes on a negotiation. So,
well, I
can
can
6 weeks right from today about, or
well, I think for new contracts signed January 1st, that won't be such a business disruption that especially with the holidays coming up. I know a lot of to get done before Thanksgiving, before Christmas. And I think if we said all new contracts that apply signed January 1st or after, but I'm not going to sit and not put it in there. If there's room to put it in, we will put it in, because we still will need to go back based on the language of the waiver by June and say, we really need to put this in. I just don't want to mention something that's going to get signed tomorrow. I have to coordinate with the legal team, coordinate with the net, just to give us a little bit of grace to sort of not create huge.
Commissioners, are we amenable to Alexis's request, or is there a big desire to hold it for tomorrow? I just need to see, I need to take the temperature here. Okay.
No, I think it's reasonable.
Yeah, good. Commissioner Maynard, are you okay?
I think it's reasonable. I just want to be clear that we have to weigh business interests versus public safety interests. And I will feel really upset at myself if there's a breach or something that happens and this date and this date are when it happens. So, you know, yes, we're very business friendly here, but we're also number one public safety. And so I want it done. I just want it done. I want it integrated as much as you possibly can do it. And any waiver that we grant, I want it to be so narrow in your day-to-day operations that this isn't a problem. I don't want that risk.
Commissioner Maynard, do you have another suggestion, or are we okay with January 1?
I don't like yes or no questions, Madam Chair.
No, I'm just asking. Right now there's the language.
Constitutional duties.
I'm sorry. To your point, I think we have the good faith, commercially reasonable steps to, I think, help address your concern. I think all of us share your concern. We're balancing, we're balancing practicalities here, not necessarily in the public. I don't think any of us, including probably our operators, are wanting to put the public's interest at risk. So I just wonder, we've got tomorrow or we've got January 1. I'm hearing those two options. Do you have another alternative? And it wasn't yes or no. If I'm sorry if I suggested that. I guess I just want to, is there something else?
I've said what I've said.
Okay. Commissioner Skinner, I don't have you on camera. Do you have a feeling about January 1st tomorrow?
Yeah,
Yes.
I'm on the other side of this. And it's okay if I'm in the minority, but my feeling is that this should take effect immediately tomorrow, in terms of the contract not yet signed because this regulation has been out there. And, you know, it's a wonder to me why the negotiations haven't included this language thus far. So I would be in favor of making this effective tomorrow in terms of, you know, just not extending the waiver on that particular question.
Thank you. Very helpful, Commissioner. And then Nina, as a lawyer here, is that do we, because I that's why I asked when did it go in effect, but I also don't want to be unreasonable because I'm kind of in Commissioner Skinner's camp. You know, it's been out there unless they really thought they were going to retreat, which we haven't really shown that inclination. What's the practicalities here in terms of your lawyer, big firm? Do you feel the pain of Alexis in a way that we don't want to be unreasonable? So that's
Well, those may be different questions, Madam Chair. I'm in addition to
all of them.
council work on this, but I do a lot of transactional work and a lot of contract work in regulated industries, and so I certainly understand the concern, and that it might take time. I do think legally you have the right to insist on this. You provided remember, this came in the normal course. This actually started with comments way back in the summer. You provided waivers, you're here. So the policy decision of whether to go or not, I think the position Commissioner Skinner just mentioned is perfectly appropriate legally. And again, the circumstance of what you do if there isn't compliance is something that I would say you have to reserve for a later time in your enforcement discretion.
What if we make it that contract started before our adoption of the regulation?
I guess my comment on that, again, just from the practicalities of being in contracts, is I can tell you that I just asked about a project that technically a client had asked me about in April 2022, and I haven't really done much. They haven't asked me to do much since then. Is that the date when it started, or when it pops up again in a month and the principals are ready to talk to start? I don't mean to suggest that the operators are going to play games with it, but I do think it just gets even more confusing. And what we're talking about here is a further extension of compliance on the contractual terms, while asking folks to, in good faith, to use commercially reasonable efforts going forward. And that seems doable on your end. Again, that's for you all to decide how far to push that, but I don't see any legal barrier to doing that. And just from my 2 cents as somebody who negotiates agreements here and there.
Okay.
So, Madam Chair, if I could, I'm not usually the one who's erring on the side of giving more time to licensees. I find myself there in an effort to move this forward, and I want them implementing. And I think, to steal Commissioner Hill's intent and sentiments, I think if you move it up to say 12/15 or 12/14 as the kickoff date, you are acknowledging the reality on the ground right now. You are acknowledging the reality on the calendar of the holidays. You are making it quickly, and they are agreeing to use commercially reasonable efforts. And so, to the extent that that can be done and rewritten prior to, say, 12/15, I think it, avoids mutiny potentially inside and in-house and outside counsel doing these contracts. But I think it also makes it clear that we want this done effective as soon as possible.
You said the 15th. Can we do the 14th? Just
the date, because we have the meeting date.
Use that rather than January 1 date. That seems like a good compromise. How does everybody feel about that? Commissioner Skinner, I know I heard you clearly, but you can also choose to vote the other way. How do you feel about
that? You have consensus, so it's
I think
I've not moved from my earlier position.
Okay, and I think I've got consensus. Commissioner Maynard, I don't know if you shifted or not. Okay. Commissioner Maynard, you're thinking. I'm looking at your expression.
I'm thinking.
Commissioner Hill is still okay with Alexis's request for more time. We're doing a little bit more consistency with December 14th. Commissioner O'Brien, that's your position. I'm happy to go with that because again, I'm thinking why wait, to Commissioner Skinner's point, but on the other hand, I bet that I'm not really appreciating the intricacies of the contracting process, although probably have done enough of that in my legal career to make my head spin as well. So, Commissioner Maynard.
I mean, I'm also appreciating putting it, to Commissioner Skinner's point, doing it.
Yeah.
And then to Mina's point, we can weigh it on any enforcement action on the back end, right? We can choose to do something or not do something if something does pop up. So that's why I'm weighing. Hey, we've got consensus. I'll vote in the positive for the 14th.
Okay, all right, then with that, Caitlin, I turn to you. That was helpful.
right.
Hopefully it gives some relief for those contracting complexities.
All right, we'll give this a try. So we're starting with 257.031. So the motion would be, I move that in accordance with 205 CMR 202.03 subsection 2, the commission issue the following waivers as further detailed in the materials in the commissioner's packet and as discussed here today, as granting the waivers meets the requirements specified in 205 CMR 102.034 and is consistent with the purposes of GL Chapter 23N. From the requirements outlined in 205 CMR 257.03 subsection 1 to all sports wagering operators through June 30th, 2024, and notwithstanding the waiver, licensees will make all commercially reasonable efforts to comply with 205 CMR 257.03 subsection 1.
So moved.
Any further discussion or recommended edits?
Second.
Oops, my apologies. Thank you, Commissioner Hill. Any edits? Any recommendations? Mina, does it matter that you've used good faith in front of commercially reasonable? Does that matter to you?
It's a little redundant, but I think it's okay in this case. It's both.
To add good faith?
I think it's fine as is.
Okay. No further comments. Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
And Commissioner Maynard.
Aye.
And I vote yes. And Commissioner Skinner, you're on and off, but we can hear you clearly. So that's important for you to know. All right. It
Okay.
is now.
Chair, should we do the next motion? The final motion?
Oh, my apologies. Yeah, thank you.
Sorry.
Thank you so much.
All right, one last motion for now. I move that in accordance with 205 CMR 202.03 subsection 2, the commission issue the following waivers as further detailed in the materials in the commissioner's packet and as discussed here today, as granting the waivers meets the requirements specified in 205 CMR 102.03 subsection 4 and is consistent with the purposes of General Law Chapter 23M. From the requirements outlined in 205 CMR 257.03 subsection 3 to all sports wagering operators through June 30th, 2024, and notwithstanding this waiver, all contracts entered into as of December 14th, 2023 must conform with the requirements of 205 CMR 257.03 subsection 3, and operators must make all commercially reasonable efforts to conform existing and ongoing contracts with 205 CMR 257.033.
So moved.
Second.
Any questions or edits as to that motion? Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
Commissioner Maynard.
Aye.
And I vote yes, 5-0. Now we are at 12:40. I've lost track, Mina, where we might be here.
Sorry, Madam Chair. So there is one more motion, I think, just as a cleanup that I would suggest that was
Going
only
backwards?
No, just on this one. If you recall, I mentioned at the outset, 25705K. Only
Oh,
draft
I was going to mention that. Ah,
really honoring vendors. But to answer your question, after this, we still have, those were the two biggest conversations we do, I think. We'll see how it goes. We do have a couple of individual sections of the reg that also had waiver requests, but I'm assuming folks will want to break before that.
I meant to mention the K, DraftKings particular request. So how do we incorporate that? Do we amend our last motion?
Caitlin, I would
Or is it a
suggest
separate?
I think it's a separate motion, but I think it's to whichever date we just set for the full compliance on all three. I think
30th.
Yeah.
Okay. If you
With
wouldn't
the
mind
same
giving me
commercial.
1 second to get myself set here.
My apologies, Caitlin.
No, it's fine. I thought I was
While
done.
Caitlin's doing that, I can give you the preview if you want, Madam Chair.
Yeah.
Would that work?
Yeah, that would be helpful. Thanks.
So, assuming we'll take a break after this, is I think what you were getting at.
We have outside parties too, and then we have an adjudicatory hearing at 3. So I'm mindful of our time frame here.
Okay, so what we have left is there's a question and set of a discussion on 257025. This is a responsible gaming reporting portion of the reg. Our recommendation may help move that one fairly quickly, but that's one. There's a question about the encryption provision. And then that's two. The second one. The third one is 25704. There were a couple of requests with respect to consent, withdrawal of consent. And then there are this is more on the cleanup side. I'm not sure if this will actually need waivers or not after all said and done. Several folks noted, I think depending on how they approached it, we're careful to note that they may need to also delay when they provide updated internal controls regulations that reflect this. I think that one, I have a proposal that hopefully we don't, won't need by then you won't need a lot of conversation.
Yeah.
May I ask one question on the 257.05K waiver? Does that need any of the conditional language at the end, or is it good as a straight motion?
I think, Caitlin, that one is, it's actually 257.051K, right? An active oversight and audit compliance. I think either way I think it's probably fine as is. This is about having an active compliance monitoring system. So it probably should, I guess, include the commercially reasonable if you're doing that for the rest.
Okay. Is it 051K? That's what you said?
Yeah, 051K.
Okay. Sorry, everyone, just give me 1 second.
Two 5705 1K, right? Yeah.
Okay, I think I'm ready.
Okay.
All right. I move that in accordance with 205 CMR 202.03 subsection 2, the Commission issue the following waivers as further detailed in the materials in the Commissioner's packet and as discussed here today, as granting the waivers meets the requirements specified in 205 CMR 102.03 subsection 4 and is consistent with the purposes of General Law Chapter 23N. From the requirements outlined in 205 CMR 257.05 subsection 1K to DraftKings through June 30th, 2024. And notwithstanding the waiver, all contracts entered into as of December 14th, 2023 must conform with the requirements of 205 CMR 257.05 1K. And the operator must make all commercially reasonable efforts to conform existing and ongoing contracts with 205 CMR 257.05 1K.
Any questions regarding Caitlin's? Nina?
Just friendly amendment. I think contracts there should say practices because this isn't just about contracts for K.
Right. Substitute
I-
for contracts for practice.
Yeah, actually contracts and practices because it's both. But,
Okay.
okay. But with that friendly amendment, I have no other thing.
Well, because there hasn't been a motion, we could just say, we could say the proposed motion that Caitlin and Nina have made. One could say, so moved with respect to that language.
Well, I have a question, Madam Chair.
Okay, Commissioner Scary, yes, please.
We'll see if
And
my.
here you are again.
I was going to say, we'll see if my system holds out long enough for it. This waiver is with respect to DraftKings only, and because it deals with contracts, should it be universal, just given the prior waiver extensions?
Nina?
I find it hard to believe that this provision has already been negotiated in the contracts.
Yeah.
But not the others.
It's not so much it's a contract provision, and I guess here's and Madam Chair, perhaps I don't want to belabor this point because this is the point related to the internal controls and everything else. 257.05 requires development and implementation of a comprehensive data privacy and security policies, and this is one particular provision of those policies is active oversight and auditing of compliance by vendors. This is probably not enough of a level of formality, but I suppose my thinking on this, and would be the comment I was going to make on the 238 piece, is if the commission can provide the sentiment, before we get to a formal vote, the sentiment that all of these are having the policies in place for the things as they are required and as they become required, then that kind of takes care of itself. It's a policy about what's required. So I'm not sure. Only one entity asked about this, so this is kind of to Commissioner Maynard's point. If others are willing to put it in a policy now that they'll do it later, a waiver might not be necessary. On the flip side, if I say today in my policy, I will make sure to fine every vendor $3 million, if they don't do this, it doesn't mean anything if I don't have to actually do that in my contracts until June 30th. So it's sort of I'm not sure there's a need for any of the waiver, frankly, on these. If maybe the better point is that the guidance from the commission is that policy should be updated as within this deadlines to reflect the substantive parts. I'm not sure, but that's maybe this one is more tied to 238. So in that sense.
Should we hold then? Is that what you're saying?
It's one suggestion, but I guess that is my spiel I was going to give about 238. So maybe folks can mull that over, and with the benefit of calories in our system or something, we can talk it over. But that's really the point. A lot of these, I understand, careful lawyering from the different operators about this, but the reality is if you're giving time for folks to implement, necessarily they're also going to be updating their systems as they go. Their policies and systems as they go, not their computer systems.
All right, so I think we need to pause and have a lunch break. I think we have to be clear that there are many items on our agenda that we actually have to get to today for vote. I think I'm right on that. I'm rolling them over. I know at least with the sports wagering, we've got to get through this. I think we have some community. We've got, there's Joe hanging in there. He's got the two entities ready to do their report, but also to the co-votes that we need to get to. That's not lost on us. So it's a adjudicatory hearing, and I'm going to turn to Heather. Shouldn't need to put a light on, but we may be running late, and the party should understand that. That's and I don't think that presents a problem legally. Just I don't want to be rude. So, but we need to have a lunch break. This has been very productive and complex. I want to just thank all the participants who come in to help us understand their viewpoint. So thank you. Commissioners, What time is it? It's at 1:20 for lunch, half an hour. Is that going to do it for you?
That works.
Okay, thanks, Commissioner Skinner, and everybody else is nodding. Commissioner Maynard, you're all set with that? Okay, excellent. Thanks, everybody. We'll return at 1:20.
Love that cat.
So he's no fool. He doesn't go out very much, right? Because he's so old. And I went to just eat my sandwich out in the front, and he raced right out, went under the porch, far, far, far side. He's deaf as a stump. And so I was trying to bribe him with treats, and he, of course, doesn't even know I'm there. So I'm like, taking these bang in the ground to get him to notice me, to finally get him back in. But I had that, I'm like, well, if he doesn't come back in, I got to stay out here. Get the cat in.
Love our pets.
How's your dog doing?
He's doing much better. He's
Oh,
he's on a medicine for old dogs, and so far it's been working.
Oh, good.
Yep. Kathy can attest. He was barking up a storm yesterday because we had a guy fixing my wood stove, and he was all over it.
Oh, good.
I'm wondering I think we've got everybody. And I think we're still live, correct? So
Yep, we are still live. I just took the screen down.
thanks, Dave. All right. So this is the Gaming Commission. We're back after a productive morning, starting bright and early at 9:30, and we're holding the meeting virtually. So I'll do a roll call. Commissioner O'Brien, good afternoon.
Just muted myself. I am here.
And Commissioner Hill.
Good afternoon. I'm here.
Thank you. Good afternoon, Commissioner Skinner.
Good afternoon.
And good afternoon, Commissioner Maynard.
Good afternoon.
So I was just going slow because I'm not sure I see Nina back yet. My
Good afternoon, Madam Chair. I'm sorry, I didn't turn my camera on, but I'm here.
There you are. Thank you. Okay. Oh my goodness. Where did we leave off, Nina? We're in the middle of 5A for the purposes of our agenda, and we're discussing a whole bunch of waivers that were requested by our operators.
Yeah, let me, if I could, I gave a little bit of a preview of what's left. Let me do that again in sort of a 20-second form. There's a couple of substantive issues left, namely encryption, and rather than name the regs, let's just name the issue first. Encryption, issues about the reporting related to responsible gaming, consent and consent withdrawal. Those are really the three that are left as substantive issues. There is then a handful of related internal controls or policies and procedures, internal controls required by 238 or policies and procedures required under 257.05 itself. And that's where we left off, was talking about those. During the break, Caitlin and I had a brief conversation, and I apologize, I don't think I articulated this well before, but the point I was getting to is it may make sense, especially if we're going to be taking up some of these issues again on the 14th, to rather than entertain waivers on the internal controls and the portions of 257.05 that have to do with how operators are documenting compliance. I think it's maybe more of an issue of clarification first to see if waivers are actually needed, to say that operators should assume that their policies will eventually need to be in compliance with the whole rule, as some of it may end up being amended or not. We talked about that, but the whole rule, and that for the purposes of the commission, what you're looking for are policies and procedures or internal controls that reflect what they are required to do as of the time they're required to do it. So between now and June 30th, the requirements will continue to develop. So I think there's an understanding that the internal controls that are there now may not be the same as what's submitted later, and that there may be a lag in submitting additional ones, because the reason you accepted some of the waivers based on the discussion earlier was that now that there's been further regulatory clarification, more scoping and sort of figuring out, well, what does this mean for our organization, for each operator, is necessary. And from my perspective, and Caitlin's at least, our thought or our recommendation is that that guidance, if you agree with what I just said, that guidance may be sufficient for now. And it certainly tells the sports wagering division and legal what to do with with in progress internal controls, rather than kind of getting too caught up in the form over the substance. That, yeah, well, this section says you have to comply with, you have to show us how you're complying with this other section, but it's circular if you don't yet have to comply with the substantive section. Does that make sense?
Really clear. I'm joking. What I am hearing, though, is that what I'm hearing is that just right now may help the regulators understand a waiver is not necessary, but that would revisit this on December 14th for further clarification that would not put them out of compliance with the regulation being in effect tomorrow without a waiver. Is that fair?
Correct. I mean, someone could make the case for technical non-compliance, but it is, a policy that I think the commission has made clear. It understands there's evolution to be had in how how operators are going to be handling these issues. And so it may not, expecting it all to be documented before they've done that work or finished doing that work may not make sense either.
Crystal and Bruce, is that helpful to you? And that's with respect to which particular item?
So this would be with respect to the portions of 238 for which waivers were asked.
Yeah.
Excuse me. And then 257.05. I guess 257.05 is data program responsibilities. It includes a whole bunch of things. There were some requests for 257.05 generally, and some for K. Okay. I think specifically, I think the point to make would simply be, whether you take a vote or express it in some other way, that it's just, the sentiment of the commission is there should be a data security policy, a data privacy security policies, but they should reflect requirements as they exist at the time, and understanding that they may need to be updated as you move forward.
Commissioners, questions for Mina on this proposal? I'm wondering if just give him the green light and the sports wagering division the green light to message this, which we're doing here publicly as well, and that if there's further clarifications that are needed, that they would be rolled over December 14th. Crystal? Are you leaning in, Crystal?
No, sorry. I just realized I'm unmuted, but I was just going to chime in when you asked earlier whether it works for sports wagering. And we've talked with Mina and others about this, so we were prepared.
Okay, excellent. Questions from Mina, commissioners? And for the sports wagering division, you haven't had any, I don't see any operator raising their hand here. Okay, if I'm not hearing any objection to that plan, I don't think we need a formal vote. Am I right, Lynn?
Yeah, I don't think we need a formal vote. It makes sense to me that based on the consensus here, the operators will understand that as the regulations are going into effect, they may need to be updating their related ICs or other data policies.
All right.
Okay. And I'm going to just make a note here. All right. So that's done. Now, Mina, do you have another really good plan?
I hope so. I'd like this to be reflected in my average of minutes per section, if possible, in case anyone's keeping that stat. 205.
Commissioner Maynard liked that, by the way. He thought that was
good. Yeah.
Okay.
205 CMR 257 025 is the next place we'll go. So this has to do with the responsible gaming reporting back piece of this. And let me just go back to the section. So this section had been inserted here. This is about data use and retention as an affirmative ask that sports wagering operators collect, and the word right now says aggregate, and we'll talk about that in a second, patrons' confidential and personally identifiable information to analyze the behavior and for purpose of identifying and developing programs and interventions to promote responsible gaming and support problem gamblers. This was sort of the positive use of data that we talked about a lot during the implementation process. And that they would be reporting every 6 months to the commission on compliance with that section. A couple of questions came up, including during the roundtable. I think first there was this question about shall collect and aggregate, and there was a question about the word aggregate, actually from the commission's expert on it, who's Assistant Director Vanderlinden on this. I think there was a misunderstanding of what the aggregate here is meant to do. This is not intended to limit a sports wagering operator from using individualized data to target help to someone who needs it. For instance, if I'm engaging in very risky bets over and over, I show a pattern of it, I keep raising my limits every hour, et cetera, and that there's an algorithm that catches that, by all means, this wouldn't be a problem for it. The reason for the word aggregate was really meant because this is coming as a report to the commission, a way for the operators to provide your data without making putting it into the public records or in a way having the commission end up with one-off pieces of information. I've come to understand a little bit further, though, that even that may end up limiting what the responsible gaming team at the commission may want to be able to do. They may need to see particular data at some point. So one thing that I know that the legal team and sports wagering have talked about is that we do intend to propose a clarification to this language in the next couple of months, and perhaps just simple as removing aggregate. But the point of it would still remain that it's kind of anonymized data is what we were really talking about, as opposed to only statistical raw data. That's what the point really was for the aggregation. That being said, the questions from operators around this that came up were DraftKings had asked for a January 1 waiver, FanDuel through July, Caesars through June 30th, kind of the same end of June, July 1st. Plainridge actually had asked through January 1, 2025 to do the first reporting. And there was a general ask really had to do, I think, with clarifying a little bit more about what is the commission looking for in the reporting out, and also because of this aggregation issue, concern about how it's done. Our suggestion, since the reporting period for this was set to be on a 6-month period anyway, is that, and several entities have asked for 6 months, and because we're clarifying it further, is for the commission to give the operators until June 30th for the first report to be provided under this section. And in the meantime, for the responsible gaming team and legal and sports wagering to work out a more detailed ask pursuant to this reg of what kind of information you're looking for, and in the form you're looking for it, for that first report in June. And again, that shouldn't limit folks from using efforts to already do this work of trying to reach people who need help. And my view is that's actually already captured to the extent an operator wants to do this, and that's easily considered within necessary to operate a sports book or sports wagering operation. So it's already covered by 257.02 and 3.
And that would be to June 30th as well.
Yes, and although that, And although not everyone asked for that, this is a reporting that's coming to the commission. And from what I understand, I think the responsible gaming team would like to have to provide more direction to operators on what they're looking for. So rather than have reports come in piecemeal from people counting 6 months from today versus that, if you just make this one, I think this one may make sense to be universal to anticipate that question.
Any questions for Mina on this? I see Mark is here weighing in, but commissioners, with respect to what Mina's proposed, do you have any concerns? And then we can hear from Mark. I'm seeing no from Commissioner Hill, Commissioner Maynard, no, Commissioner O'Brien, no, and Commissioner Skinner, no. Mark, are we all set?
Yeah, if I can just add something here. The commission has begun work looking at identifying risky player behavior and an appropriate response. And that would rest largely on our operators having some system in place to do that. So this relates back to the RFI the commission released, and I'm still sorting through the responses to that. And so, I think that I still have a lot to learn in this space, but as I read this regulation and I consulted with Dr. Michael Wall, the term aggregate did concern both of us, specifically as it relates to responsible gaming initiatives and programs.
Okay, excellent, thank you. And Dr. Wall was very helpful that day, so we appreciate it. All right, should we have a vote on this, or is this enough of a consensus clear that I guess we do have to have one because it is giving a waiver, correct, Caitlin?
Yeah, I would suggest a vote on this one.
Okay, want to give us some help if you're ready?
I will, and let me just ask Mina for one question. The waiver would be through June 30th, 2024 for the first report to be provided to the commission, right? Specifically.
Correct.
Okay.
Although I think that yes. In the meantime, it's really more of a direction to start implementing these procedures. There's really not much to enforce otherwise on that.
Okay. Great. Okay, in that case, the motion would be, I move that in accordance with 205 CMR 202.03 subsection 2, the commission issue the following waivers as further detailed in the materials in the commissioner's packet and as discussed here today. As granting the waivers meets the requirements specified in 205 CMR 102.03 subsection 4 and is consistent with the purposes of General Law Chapter 23M. From the requirements, from the requirements outlined in 205 CMR 257.02 subsection 5 to all sports wagering operators, a waiver through June 30th, 2024 for the first report to be provided to the commission.
That motion in mind, do I have a so moved?
So moved.
Thank you. Do I have a second? Do I have discussion?
Second.
Thank you, Commissioner Skinner. Is there any discussion? Okay, Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
I'm an aye, Madam Chair, and just FYI, I'm off camera but fully engaged. I'm just trying to reduce the strain on my network. I apologize.
And you did say aye, correct?
I did.
Thank you so much. And Commissioner Maynard.
Aye.
Okay, and I vote yes, 5-0. Thanks. Thank you, and really, it's I'm so glad it was an iterative discussion among our folks here with Mark's team and everything. So thank you.
Thank you, Madam Chair. So moving on, we have two left. 257.034. This is the portion of 257.03 we haven't talked about yet. It has to do with encryption. This one, if some of the representatives of the operators are still here, they may have more to add about what exactly the issue is, but to state it as we understand it, this provision was requiring the encryption hashing, which is really one-way encryption, as I understand it too, of all patron confidential information or PII or personal information. There are a couple of questions that came around this that I think we clarified. One is, what if it's already in the public domain? In that case, it's really this, and what if it's on the patron's device, but not with the operator? And the short answer to all of that is that the clarification we provided is that this is about what's within the care, custody, and control of the operator, and by extension, vendors that they share it with, et cetera. It's really to limit access as opposed to limit use of the data, to limit access to the appropriate people. After that clarification, I think we got fewer waiver requests than we might have otherwise gotten. However, there were still a couple of questions that came up, namely from DraftKings and BetMGM. And I'll use BetMGM's comment, which I think reflects sentiment that we heard elsewhere, which is that the particular use of that particular technology, encryption, may not make sense in all cases. And so they were looking for either a permanent waiver or a waiver, if I understood correctly. They were looking for a permanent waiver. DraftKings was looking for either end of 2024 or mid 2025, or permanently, depending on which part of this. The issue that I think is coming up, maybe another one that is capable of being resolved, less so by trying to come up with the date by which all this can happen, but by adding language to the reg that allows for more of a performance-based standard, where if operators can demonstrate that they have other methods in place that are as protective and that encryption or hashing may not make sense here, that may be sufficient. So that was one approach that sports wagering and legal talked about as resolving this. That would be another thing that could come back for a regulatory change, along with the change to aggregate. So perhaps a shorter waiver might be appropriate while we consider that. Talk through it again with GLI and Commission's IT and the AG's office's IT teams, as Commissioner Bryan suggested earlier. I will say these questions, some of these questions came up during the comment period. We did take some of those comments, and hashing was one addition from there. And I don't know if there may be more conversation between more technically minded folks needed to try to make sure everyone's speaking the same language, because I think some of the concerns, the way they're stated, seem to reflect a belief that data will be encrypted so much that it can't be used. But this is really about encryption when it's traveling from one entity to another. And so that the wrong people who aren't authorized to see the data should see the data, as opposed to then it being decrypted by the third party that is authorized to see it. So this one struck us based on the waiver request as requiring a little bit more clarification, and thus maybe a short waiver until whether that's 3 months, 6 months to try to get at that.
So not December 14th.
I think longer than December 14th, because I think we're anticipating potentially a regulatory change. And to the extent that even if there isn't one, it's just a clarification, it's more of an implementation issue than a simple.
Okay. That's helpful. And in looking at the request, is there any guidance on the shorter time frame that you're thinking of?
I'm not sure I follow the question.
Well, I guess I haven't gone through the dates that requested between the two. So is there any guidance from their time frame? I know it's a different ask, but I'm just wondering.
The shortest time frame on this one that was specifically asked was December 2024. But I think, and in fairness to them, I think this was DraftKings more part of the ask of to do all the implementation at once.
Ask, I understand, but now that I know that, that's not going to help us either. So to get the reg language in place and underway, is do we make it June 30th again? Because you did say 6 months, or should it be half that?
I think this, what the question, but I don't want to overstep I'm not an IT expert, but I do think the issue here is what the operators have represented to us is that they do have they have measures in place now. You didn't waive 205 CMR 257.03.2, which requires continuing to have reasonable measures in place. So there will be protections in place. Whether this particular protections in place in the meantime is the only thing you'd be waiving. So for that reason, I can see a reasonable decision to go out to June 30th. But I think this one we've had the hardest time figuring out exactly the implementation timeline. For how much more would be needed. And again, because some of the ask is about permanent waiver, I think part of the issue is that some feel that there may be more effective methods that they can show us are more effective than following this one.
Right, and I guess I heard that. That's what made me think if you were going to have discussions early on, I guess then the way the right could offer that kind of relief, right? If they're able to demonstrate it's effective than what's offered. Commissioners, do you have a time frame in mind? Commissioner O'Brien, Commissioner Hill?
I was thinking 3 months. Like the end of February-ish.
Yeah. Crystal and Bruce, what do you think? Crystal?
Okay with me. I mean, it doesn't really impact us either way. So your comfort we'll follow up with.
I think if this implicates sort of amendments, I think that's fine. End of February.
Okay, because we would have to have the amendment done by that time, right?
Well, it's a good question. It's unlikely that we would have it completely done, like through the full promulgation process, unless we did it by emergency. So I think we could get through the first step of the amendment process, and then if we had to extend the waiver, we could extend the waiver depending on what the reg looks like, if that makes sense.
Want to do March 1st or last day of February? March 1st, I'm not sure if it's February 28th or February 29th.
It's the 29th, so maybe March 1st. Yeah.
I didn't want to say that, but couldn't decide. All right, so March 1st, and then we'll see where we are in our regulatory piece. But they've asked if it can be safer, that we would yield to that, of course. Commissioner Caitlin.
This would be universal with that, or would it be for the two?
Caitlin, my recommendation on this one would be a universal, only because if the reg is going to change, then that may cause, if it's going to encourage people to look at some of the technologies or other companies are using instead, that may be worth giving that additional time.
Great.
Any questions, Commissioner? Commissioner Skinner, are you all set? Do you have any questions or comments?
No questions.
Okay. Turn to a recommended or proposed motion, Caitlin.
Here we go. The proposed motion would be, I move that in accordance with 205 CMR 202.03 subsection 2, the Commission issue the following waivers as further detailed in the materials in the Commissioner's packet and as discussed here today. As granting the waivers meets the requirements specified in 205 CMR 102.03 subsection 4 and is consistent with the purposes of GL Chapter 23N. From the requirements outlined in 205 CMR 257.03 subsection 4 to all sports wagering operators through March 1st, 2024.
So moved.
Thank you.
Second.
Thanks, Commissioner. All right, Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
And Commissioner Maynard.
Aye.
And I vote yes. 5-0, thanks.
All right. So, Madam Chair, the last one on my list, if I'm keeping track appropriately here, is 25704. This is regarding patron access. This was another one where, depending on the operator, we got different levels of granularity about which part they were asking for a waiver from. Some FanDuel and Fanatics both mentioned all of 04, BetMGM, and asked about 1D, which is really the imposition of additional restrictions on the use of data, and Caesars asked for that as well, and then Better asked actually for 1A through C. So there are sort of a couple of different concerns at play here. One is the more technical implementation one, similar to the opt-in. There was a just ask for more time to be able to design the privacy notices, information, opt-outs, et cetera, based on clarifications that have been provided so far by the commission. The other concern was a more fundamental one that had been raised, that there was a concern about over-promising to patrons what can be done with their data, or having too many different options, for meaning that this sort of some people read the reg, I think, as giving a patron the ability to say, well, I don't mind if you market my stuff to this entity, but not that entity, and requiring that level of granularity. In our clarifications and conversations, I think we tried to clarify that, one, the patrons, and I know that this was something the commission discussed when you implemented the reg, that if the operator believes it is necessary to hold on to data and a patron's asking for it to be deleted, that the operator can still hold on to it, because especially if it's for fraud or safety issues or security issues. Two, in terms of the options offered, it does not need to be entirely directed by the patron. It's sort of giving options of, you may have opted into all third-party marketing and it's out, and it's really up to the operators how granular they want to get into it. All of that being said, because of the different clarifications, I think this is another one where the dates differed. There was really from March 1, 2024 from Better, who focused more on the implementation piece. Caesars, Fanatics, and FanDuel were June, November, and October, respectively. So between June and October of next year. BetMGM focused on the provision that had to do with sort of the access control, and for them, it was more of a permanent issue, as opposed to an implementation issue. And I think it was, again, this sort of, they're not comfortable with how the language is written, for the purposes of making sure people can fairly expect that their data, that not all requests with respect to data may be met. Our suggestion, as this has to do with the implementation piece, is that you set a date, that if you are going to grant waivers, that this one probably does make sense to tie back for the individuals who did ask, because they are asking about specific implementation pieces, and that should be for a date no later, certainly, than the opt-in dates, because I would imagine they get rolled out together. You opt in probably through the same methods you opt out. With respect to MGM's question, we certainly can look at clarifying this further when we come back with some of the other issues we mentioned. I think we may just have slight different, well, not slight, I think we have that we might have, a narrower interpretation of what patrons may be required to be permitted to do than that MGM may be worrying about. But I understand what they're saying. I'm just not sure we read the language the same way.
I think the best approach would be to walk through each particular one, right?
Each particular ask, you mean?
Yeah, that's what you're thinking that we,
I think so. I will say FanDuel and Fanatics ask is for the whole of 25704.
yeah.
Although I'm not sure, for instance, 25704 also requires providing a written request that grants or denies a request, and gets at issues of when data could be erased, all of that. So I'm not sure if they're asking, I'm not sure if that's what they, at least with respect to FanDuel's, I understand Fanatics to be part of that larger question about implementation of the whole program.
I might make one suggestion, cognizant of timing and that we have an adjudicatory hearing too. It would be possible to give a waiver until we could roll this section to the next meeting or something like that, give the waiver until that time and then take it back up if this is going to be a lengthy discussion about each particular request.
Commissioners, we're rolling this over to December 14th, or do we continue on? What we do have another sports wagering matter. We do have our two community litigation foundation items that we have to vote on. We have two presentations. On the other hand, the adjudicatory hearing could be pressed back a bit, I'm sure. So what do you want to do?
I would have no problem rolling this over to the 14th, Madam Chair.
Okay, folks agree with Commissioner Hill? Commissioner Skinner? I got a thumbs up from the other three.
I'm good with that.
Okay.
You wouldn't mind giving me 1 minute to get the language together?
Thanks, and maybe for the 14th, we can figure out a little bit more precisely about what they're requesting. I understand you'd like it to be tailored in terms of timing, Nina. Okay.
Okay.
I had a little harder time following that one.
All right. Are we ready for the motion? Or?
Yeah.
Great. So the proposed motion would be, I move that in accordance with 205 CMR 202.03 subsection 2, the commission issue the following waivers as further detailed in the materials in the commissioner's packet and as discussed here today. As granting the waivers meets the requirements specified in 205 CMR 102.03 subsection 4 and is consistent with the purposes of General Law Chapter 23N. From the requirements outlined in 205 CMR 238. Oh, I'm sorry. Roll that back. From the requirements outlined in 205 CMR 257.04 to BetMGM. Nope, excuse me. Yep, to FanDuel, Fanatics, BetMGM, Better, and Caesars through December 15th, 2023, on the condition that these waivers will be addressed at the December 14th, 2023 meeting.
With that proposal, thanks, Eileen. Okay,
Second.
thanks. All right, Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
And Commissioner Maynard.
Aye.
I vote yes. So we got through really 90%, Nina, correct?
I believe so, yeah. I think we're actually, so we will take the few things that I know are coming up on the 14th and work on those between now and then. I appreciate it.
Yeah, and Caitlin, if you could just have that list ready from, I've taken notes, but I'm sure they're not precise for Monday, the agenda setting, so we can get them right into the December. Thanks, that'll be really helpful. Thanks so much. All right. Anything else legal? And Nina, before we move on to the next sports wagering matter.
No, thank you for your time and attention to this. I know it took a long time, but it's great to get through a lot of this.
Yeah, nothing from me. Thank you.
And then and so that we're prepped again, you'll just narrow down our packet for just that last section, and well, the other things we have to be really helpful. All right. I'm looking for a document, my apologies. Okay. Then we're, Mina, thank you so much. Are you sticking around? Are you?
I don't think so unless, I'm not going to even ask if there are requests, but unless there's something that I'm forgetting, I don't think I am.
Well, you can stay if you'd like. Anyway,
Thank you.
Thank you so much. We really appreciate your help. Okay, so we're going to move on to item 5C, which is a DraftKings request, and I'm going to turn back to Director Band and hi, Andrew.
Yes, interim operations manager Andrew Stassen will be handling this. Andrew.
Yep, thanks, Bruce. Good afternoon, Madam Chair, Commissioners. Only one item for review today. Because on page 185 of your packet, this is a request from our operator DraftKings requesting the Commission to authorize the voiding of wagers after becoming aware of an incorrect market totals on an NBA game from dated October 24th in a matchup between the Los Angeles Lakers and the Denver Nuggets. Pursuant to 205 CMR 238.35 Section 2, a sports wagering operator may request the Commission to authorize the cancellation or voiding of all wagers of any specific type, kind, or subject. Under Section 4, the Commission shall issue a written order granting or denying the request to cancel or void the wager or wagers. In your packet, we have prepared a brief memo summarizing the incident and providing a timeline of the events as well. As the incident states, on October 24th, between 4:22 p.m. and 4:35 p.m. Eastern Time, approximately 13 minutes, DraftKings offered incorrect odds on same-game parlay markets. The same-game parlay vendor, Sportcast, released first quarter player markets for the game, despite DraftKings previously communicating developmental work was needed to handle the first quarter markets. As a result, the first quarter player markets were offered as full game markets, as the DraftKings platform interpreted the odds as full game odds rather than first quarter odds. And before I move on, just like to give a quick example of one of the affected markets. You all may know LeBron James of the Los Angeles Lakers, who last season he averaged 55 games, averaged nearly 30 points, 8 rebounds, and 6 assists per game. He was offered at same game parlay odds of over under 8.5 points, 2.5 rebounds, and 6.5 assists for the full game. For reference, the correct LeBron James full game totals on the same markets were simultaneously being offered by DraftKings as non-same game parlay player prop wagers as over under 23.5 points, 7.5 rebounds, and 7.5 assists. And this didn't just affect LeBron James wagers. All players in the game from both teams were affected for this matchup. As a result, a total of 178 wagers were placed on these impacted markets by a total of 137 individual customers for a total handle of $4,182.36, with a total liability to DraftKings of $575,436.82. The memo in your packet does provide a timeline, but just to summarize, on October 23rd at 1:12 p.m. Eastern Time, one day prior to the game, Sportcast, who I mentioned earlier is the same game parlay vendor, advised DraftKings they intended to offer new first quarter markets. The next day, on October 24th at 11:51 a.m., a little over 22 hours later, DraftKings informed Sportcast they are unable to ingest the new first quarter lines. Later that same day at 4:22, Sportcast released the first quarter player markets. Approximately 11 minutes later at 4:33 p.m., DraftKings reported to Sportcast the player markets are being offered at incorrect lines. And approximately 2 minutes later at 4:35 p.m., Sportcast suspended the offerings. As mentioned, DraftKings identified the root cause as Sportcast releasing the first quarter markets for the game after DraftKings communicated development work was needed to handle these markets. As for remediation, DraftKings has advised Sportcast they will not be offering first quarter player markets until further development work has been completed and implemented. In conclusion, the Sports Wagering Division has reviewed the requests, incident report, and remediation provided by DraftKings and confirms all requirements have been met pursuant to 205 CMR 238.35 Section 2, and has no reservations about moving forward and processing this request to void all affected wagers. To note, we do have DraftKings representative, Senior Director of Regulatory Operations, Jacob List, on the meeting to help answer any additional questions as well. Chair.
Thanks, Andrew. Commissioners, questions for either Andrew or for Mr. List? Commissioner O'Brien?
So I'm wondering how it is that if you indicate to the outside party that you can't list it, how does it show up anyway?
Jacob, that might be for you.
Yeah, I'm sorry. That was Mr. List.
Sure. Firstly, good afternoon, Chair and Commissioners. Thank you for the opportunity to speak about the error. So it is summarized in the incident report, but essentially we are sent data from the provider that we use for Same Game Parlay, Sportcast, and then our system interprets the data that they send us, translates it correctly for the markets that the customer sees on the website. In this case, our system was set up to translate full game proposition markets, the Same Game Parlay, but not proposition markets for the first quarter. We instructed the vendor of this, and we believe there was some type of miscommunication on the vendor side, and they sent us that first quarter information anyway. So we incorrectly translated it into full-time markets on our side.
So I'm trying to figure out why the obligation to pay wouldn't fall on the vendor if they did something erroneous. Like, is it so clearly erroneous? Is that what you're saying? Is it was so clearly erroneous as to be absurd?
We would say this is a circumstance of very clear, obvious error. So some facets of behavior that would lead us to categorize it that way. Customers, when an error affects multiple markets and customers notice and then they parlay them all together, that's an indication that the customers clearly know that's an error. There's also instances of customers talking online, so on Twitter and other forums saying, stuff along the lines of, look, there's this huge error, go bet it on DraftKings. So we would say that, yes, we take void requests as an extreme exception, very rare, but in this case, we do think it was an extremely obvious error and fits the description of that in our rules and the regulation.
So was there social media chatter about this particular bet?
Yes.
And how much was bet in total? I know you give the payout, right?
Total bet was $4,182.36, I believe.
Okay, so that's the total handle, and then the payout, if honored, is a little over $500,000.
Yes.
So you told them not to send it, that you had to do more build out. It didn't, it came through anyway. And then it says the remediation is to tell them once again, you're not ready till more build out.
There's multiple bullet points in the remediation. I don't know if you want me to go back over them, but it's not only that.
Okay. So in addition to that, what's the stopgap so that it wouldn't accidentally feed into the system again?
Commissioner O'Brien, I couldn't hear your last part.
Oh, wondering that in addition to sort of reiterating that the system can't handle it, what are the other two remediation measures?
So essentially what happened on the vendor side was when we told the vendor that we weren't set up to handle this, they triaged it internally, and we believe they sent it to the wrong party to answer the question. And that led to a delay in it getting to the correct person to answer the question. So we've asked the vendor to review their internal communications process around this type of thing, which they are. We are actually also moving to an in-house version of this specific NBA Same Game Parlay product. So we actually won't be subject to potential communication error for NBA in any case for this particular vendor. Yeah.
Mm-hmm. Can you remind us? I looked at the red last night, but the this is under part of the reg that's quite general. This kind of correction.
Mhm.
Do you have it that you can share with us?
Madam Chair, I didn't hear you. Could you repeat that?
Regulation, the controlling reg, because it's quite general. I mean, and I looked at it last night. I just didn't. I don't have it in front of me, but I wonder if it might be helpful for the commissioners to know what, you know, the regulation that DraftKings is filing under.
I had some follow-up questions when
Okay. If you don't mind,
when you're ready.
Yeah, thank you. I don't know if Rod, you're able to get it or.
Chair, I have the reg pulled up. I don't
Thank
know if
you.
Chair, do you want me to share the screen?
Thanks so much, Andrew. That'd be helpful, just so everybody has it while we're discussing it too. We have, of course, the memorandum that's in the packet. Thank you.
The screen.
Okay.
So this is 238.35, section 2, for all circumstances not set forth in 238.35.1 that deals with obvious errors.
Okay. So that helps for a framework, perhaps, like here, Commissioner Skinner has some follow-up questions.
Should I pull this down?
Yeah, sorry.
That's
I'm
okay.
having
I didn't know
difficulty
you were
hearing you.
back, so I thought.
No,
it might
I'm
be-
here.
If you have it ready again, because it might be helpful to just walk us through the requirements too. Okay. Thanks.
You want me to pull this down, Madam Chair?
You may, please. Thank you, if that's helpful to Commissioner Skinner.
I'm sorry. Are you
Commissioner,
telling me
do
to?
you have follow-up questions? Do you have follow-up
I
questions?
do. I'm sorry. I'm all screwed up today. I'm sorry.
Not a
I'm doing by
problem.
phone.
We don't
Okay,
worry.
so, Mr. List, I appreciate you expounding on the reasons or I guess the gap in communication on the Sportcast side. I didn't find that information in the material, but just expanding on Commissioner O'Brien's questions, I was wondering, you know, whether this is the responsibility of Sportcast to pay out these wagers. So is there an agreement or does the agreement between you folks and Sportcast provide for a remedy for this scenario? For instance, is there an indemnity clause that you could point to in terms of getting a resolution to this? Should the commission not grant the request to void?
I'm not. So like the commercial arrangement with the partner is not my area of expertise. I'm also really not sure if the details of the commercial contract with the vendor would be something that we would want to talk about in a public forum.
Mm-hmm. I mean, it doesn't sound like, you know, as one commissioner, I mean, it's clear that this was to me, that this was an obvious error. And so I am inclined to vote in the affirmative to grant the request, but just in general, it would be good to know because it's not covered here, but in instances of, say, gross negligence or where there's a malicious intent, if you will, I'd want to know if there is something else that the operators might be able to draw on in terms of getting some relief should their request not be granted.
I mean, we've certainly had regulatory bodies, request certain details about the nature of contractual terms that we have in vendors if it was specific interest for a certain reason. And I think that's certainly something, if you wanted to request of us either in this context or a different circumstance, we'd certainly work with you to provide that information. Generally, yeah, it's just not something I'm sure that we would provide in this forum.
Yeah, I am interested in it generally, and I'm making the request now. And so if you could follow up with our sports wagering division, I'd appreciate that.
Yeah, we will do that, absolutely.
So I did have a follow-up question in light of the statute and the criterion. And it's really subsection C that I'm struggling with.
The regulation or statute?
The regulation.
Sorry, if we could bring it
So
up.
there's three criterion, A, B, and C.
Yeah,
And he says,
if
explaining
we could
why.
bring it up again, please. I'm sorry, so we're all looking at it. Thanks so much, Commissioner Bryan.
Yep, this is an explanation why canceling or voiding the wager is in the best interest of the Commonwealth or ensures the integrity of the sports wagering industry. So if you can speak to that as opposed to, geez, it was a mistake that somebody hopped on advantage of 11 minutes. Because there's sort of two ways to look at it. And so the submission that we got doesn't really speak to C.
That's
sure. I mean, I can speak to that briefly. First, I go, I guess, back to reiterating the point that this is a truly exceptional circumstance. I believe that these type of regulations exist because in truly exceptional circumstances, it does make sense for operators to have some type of protection for this scenario. This was an error that not only affected Massachusetts. So without going into the details of the total math, we're only looking at a specific liability in one jurisdiction. So these are sort of almost black swan type events, but it's important that I think as an industry, that we do have some type of protection should something like this occur, particularly when there are a lot of controls in place to prevent this type of thing, included in the monitoring we have in place to pick it up quickly. But the magnitude of the error can also be somewhat arbitrary compared to the size of the control failure. And so whether it's 500,000 or 5 million or 5 billion, there is, I think it's important as an industry that there is some type of recourse for an operator for a truly exceptional circumstance.
And have any of the other jurisdictions refused to void?
I'm actually also not sure if that's something that's public information. So yeah, that is information that we do have the status of the void request for every jurisdiction. Yeah, but I'm not sure I'm at liberty to share in this forum. So certainly I can say that the vast majority of jurisdictions have permitted us to void.
I would want the question Commissioner Skinner asked, and then that question to me bear on my adjudication of this request.
Yeah.
Can I ask for Commissioner Skinner to repeat her request, please? And I just
Madam Chair, sure. I'm asking if there is in the agreement between the operator and the vendor, whether there is a remedy provided for in this kind of a scenario. I understand that the assertion by DraftKings is that this is a clear error. Notwithstanding that, I'm curious to know whether there is indemnity language in any such agreement. On top of that, I wonder, is this something that an insurance policy would cover?
Commissioner Maynard.
Thank you, Madam Chair. I join my fellow commissioners in asking for additional information, but this question is actually not for Mr. List. This is for our legal team. Is 940 CMR 3.0 or any other state law applicable to this situation. I'm thinking of any consumer rights that exist under Consumer Affairs and Business Regulation, the Attorney General's office, any place where there's a price posted and not followed situation. And has it ever been extended to something like this? I'm not sure. It would weigh on how I adjudicate.
Although our regulation permits it right now, right?
You need to follow other applicable laws in the Commonwealth, is my understanding on anything that we do.
I know that, but you got my, well, Commissioner Maynard, I'm in agreement with you, but I'm hoping that we didn't miss that, is what I'm thinking. But you're raising a good point. I'm hoping that we didn't miss that. Okay, so the issue I'm struggling with is we have patrons right now who are looking to be, no, that they haven't been paid.
The wages are currently in pending status in
They're
Massachusetts.
in pending state without clarity, and we don't know the status across the country. In other words, we might not be first, we might not be last.
I think that question is something I want to quickly seek legal clearance internally about, but I think it's something we can sort of information that we can probably provide to you extremely quickly, potentially today.
I thought Commissioner Maynard was also going to ask maybe the question to follow up. Our regulation isn't an outlier. Most states allow for this kind of, I see, Bruce, I think this is familiar territory to you, right?
Sorry, I couldn't get that unmuted. Yes, that's correct. Most places do allow void wages.
The question I did pose, though, Madam Chair, is legal going to answer that now, or do we need more time? Probably need more time.
I wondered if they are, that's fair, because I know it would be hard for them to probably answer that quickly. I'm just, as I said, I'm hoping that we didn't miss something. I get what you were asking completely. On the consumer protection situation, Caitlin?
I worked on this reg, and that is not something that I remember looking into as part of it, but I've just taken a note, and we can absolutely go back and take a look at that. I remember a lot of the conversation around this reg related to separating sort of what was a very there's no discretion, right? There were errors where it was a clear error and there's no discretion in determining versus sort of the idea of an obvious error that might require discretion.
I remember that.
But yes, I will look into that, Commissioner Maynard, for you.
Todd, were you weighing in?
I was just going to add to what Caitlin said. I don't recall that we've ever made use of the consumer protection laws in this context. Of course, this is certainly a slightly emerging area for us that we haven't had occasion to navigate. So it might be a little bit different. And as Caitlin said, worth taking a look at. But I don't believe we've ever done that before.
The AG's office reviewed this, though, correct?
I'm not sure if they reviewed this particular. In fact, I don't think we sent this particular.
This was a GLI generated regulation, if you will.
I don't know what that means. I'm sorry.
Well, they helped us prepare this one.
GLI drafted it.
GLI. I'm sorry. I thought you said TLI. Sorry. It's a new acronym to me. Thank you.
So the other, just for Mr. List's edification, so the two issues that I'm need further sort of explanation or argument on is whether the facts and circumstances you've put forward is it seems to be, you're saying it trends toward integrity of the sports wagering industry. And then we have another section that talks about writing orders and different criterion to take into account. And one of those, if you go to 4C, is whether allowing it or disallowing it would be unfair to the patron. And so it's a little bit of what Commissioner Maynard asked in terms of if you post something is it unfair to then say, well, you typed it in wrong and therefore we're not going to do it, which we did have some of this conversation during the reg. So maybe if you can speak to those 2 points a little more.
I mean, so the second one you raised, I guess, is the most in front of mind. I guess I go back to the clearness and obviousness of the error. This is not someone accidentally put a 20% off sale sign on a couch, and the seller of the couch ends up having to honor the sale price of the couch. This is patrons who noticed 5 similar errors in a player prop of almost certainty outcomes, parlayed them all together with, let's say, a $10 bet for tens of thousands of, or at least thousands of winnings. So the question is really, you know, is that the type of scenario that I guess fits into this kind of conversation of the patron, you know, just happened to see this out there and bet it, and therefore what they did should be on it. That's what really this is an obvious error section exists to distinguish from that type of customer situation. And the first part of your question, if you could please repeat.
Sure, it's a big basis for whether, in my view, we avoid something like this is the interest of the Commonwealth and the integrity of the industry. And you've spoken a lot, obviously, about the business consequences of allowing this to go forward, which I can appreciate. But can you expand on how that speaks to the integrity of either the event or the sports wagering industry in terms of if we said we're not letting you avoid it?
I mean, I didn't think it would set if we set a precedent where this type of situation wasn't voidable, then certainly of the type of exceptional, you know, examples that I made, you know, certainly it could cause some significant problems for operators down the line. If you'd like, I guess, like a more detailed answer than that, we could certainly follow up with more information there as well. But I think, you know, that is the basic concept at play.
Okay.
I guess I have one follow-up that I'm thinking about based upon Commissioner O'Brien's question. Mr. List, I understand that you just described a scenario where a sharp-like player saw what happened and constructed this parlay. What about what if it's one player that just honestly put together the parlay that way? How am I supposed to think about it? How would you think of it?
Yeah, so as DraftKings as a company, probably one of the highest priorities we have is to make our customers happy and bring a pro customer company. It's very like pro customer brand driven, you know, type of voice that we have. So if we encounter those type of situations, and we do have information about our players, customers write in and they complain, and if we do think that we have someone that fits into that category, then we typically provide them with some type of make good, or in any case. In fact, we may have done this already for some players who have had wagers out there. Yes, I would say it's hard to get it right for 100% of populations when there's any type of issue. But if we were to realize that anyone had sort of fit into that category that you mentioned, and we certainly do our utmost to make sure they want to keep betting with DraftKings.
Thank you.
Commissioners, if I may, in DraftKings house rules, an error is defined as an example, not limited to this, but bets placed at odds that are materially different from those available in the general market at the time the bet was placed. In your packet, as I summarized earlier, that the errors are for the same game parlay markets, whereas the normal player odds for all the players in those games are at their correct totals. So if you went and wanted to bet the over/under on any player without the same game parlay, you would be wagering on the correct odds. When they opened up the app or their sportsbook and they went into the same game parlay markets, those were the incorrect odds. If that helps at all.
Andrew, that's really helpful and a good reminder. And it does support the integrity of the element D, because we have to be able to have the customers rely on the house rules. And then, of course, we have the obvious error discussion that we spent a lot of time on. Does that help you, Commissioner O'Brien?
It doesn't outweigh the other questions that I have and have asked already.
But in terms of meeting element C of the regulation, I guess.
Yeah, see, and now I can see both sides in terms of before, to be blunt, I really was not seeing this as voiding it, speaking to either the best interest of the Commonwealth or in the integrity of the industry. It was more a business. It was to the benefit and the interest in the business that would have to pay out, which is why I initially asked the question that Commissioner Skinner asked, which is indemnification.
Yeah.
And I can see that the House rules being consistent would speak to that. I don't know if it overcomes the other questions that I have about some of the questions Commissioner Maynard has raised in terms of, if somebody's really sharp and on top of things and puts it together, is that really something that we void under this or not?
Commissioner Hill, what do you think?
This has been a very good debate and discussion, but I'm going to be very frank with you. I think this was an obvious mistake. And I have no problem voiding this bet as we stand here at this moment. I do and did have the same question as Commissioner Skinner did in regards to the question that she had regarding, your partnership with the company and if they should be on the hook for this. But overall, it was clearly an obvious mistake, in my view. And I don't see why we would not, at this point, void this. But that's my feeling as one commissioner.
And void it and get back to the patrons with some clarity, right?
Yep.
Okay. Does a House rule element, help?
I had one other question though. In fact, you talked about there may be patrons who were given some sort of compensation, sort of knowing that this is either on hold or might be voided. Was every patron who put a bet on this treated the same, or is there any disparate treatment here? Because that would, to me, speak to, integrity of the system or fairness to the patrons.
All of the bets are in the same pending state. So in terms of
but didn't you say that you may have given some sort of comps or incentives or something to some of these patrons?
Yeah, so patrons will write into us, I guess, and complain about a myriad of things. And we'll look into each of those, like complaints, case by case. And so, a patron who has never played with DraftKings before and suddenly opens an account, and the first thing they do is parlay 5 errors together and complains to us, we may, from a discretionary, like bonusing perspective, treat differently than someone who is a casual player that's a typical sort of customer of the type that we may think would have stumbled on this and betted in the type of way that you have discussed today, and is complaining because their wager has been sitting in limbo for a long period of time. then we may provide them some type of discretionary bonus. That's accurate.
I would be troubled by them, any customer or patron who went and did this, not being treated the same in terms of compensation for avoided wager. I would assume they'd get back the money they put in. And if anybody got anything above and beyond that, I would hope everyone was treated the same, but that's just me. That's one commissioner.
Well, I guess like just to play this through quickly, I understand what you're saying. So we've refunded the bets for this in almost every jurisdiction. If a customer is complaining about just the non-settlement of their bet, we might preemptively give that refund to get ahead of where we think this is going. But the way to end by treating every customer equally would potentially be then once we get to settling the bets, then those people might not be allowed to double up. So it's easily like we want to get to the equal treatment of customers, but we don't necessarily want them to be held up on our part because of this type of regulatory engagement that can move at very different speeds in different jurisdictions.
Yeah, I'm not viewing it as the regulator speed. It's just the error was on the part of you and your vendor. And so I would think correcting it, the remedy would be the same no matter who the patron is.
Right, but so getting to the same remedy would be if we had preempted a bonus to a customer, not allowing them to double dip per se, if we were to void all of these wages, if the commission were to allow that.
Commissioners, do you have any other questions or comments? Questions, Andrew? Do you want to restate the recommendations for things?
Yeah, certainly. So we have no reservations on moving forward with canceling or avoiding all of these wagers today presented by DraftKings.
Could you say the last part again, Andrew?
Yeah, so we have no reservations about moving forward with voiding or canceling all the wagers with regards to this incident from DraftKings. Sorry.
So yeah, to be clear, Madam Chair, I'm not in a position to vote today, given I've asked for some things that are outstanding and understandably maybe things that DraftKings doesn't want to discuss in public.
Okay.
Don't know how the other commissioners.
Commissioner Skinner, I know you asked for information as well. Has the discussion that we've had since that request made you more comfortable to vote today?
So I was comfortable voting today anyway, because I do agree that this is an obvious error. And, you know, for those kinds of errors, you know, whether or not there's any indemnification from the vendor, you know, I think that's irrelevant in that context. But I would just, for general purposes, like the question to be answered. And I certainly want to respect my fellow commissioner who is not comfortable voting today. So just in that regard, I do think we should put this off until we are all comfortable voting.
Commissioner O'Brien, what is your request again, please?
I want to know the indemnification. I want to know what the status is of the adjudications to void in the other jurisdictions. And I want to know whether all the patrons have been treated equally.
Okay, so let's just peel this back. The first one on the indemnification, that's a contractual question. I presume that could be protected, or it could be also a matter of public release. Todd, help us out on indemnification. I do know that Mr. List was struggling with whether or not he could deliver to us information on the status of other jurisdictions. And then the final one, Commissioner, you know, in terms of, I'm just going to beg to differ with you on that.
That's fine.
You know, it would be great to think that every customer is going to be treated exactly the same. What I thought I heard, and Mr. List can correct me, is that they're exercising some of their business judgment around their customer service, and that it would be some kind of customer credits or that kind of thing. And that he hadn't heard from them they weren't going to go back to every customer and give that. Are you saying that that's something that's expected? Because I don't believe.
I'm not saying that it's expected, but when I look at the criterion of whether it's unfair to patrons, contrary to any sort of public policy, best interest of the Commonwealth, or of the industry, that's a factor for me as one commissioner.
Okay, and because we certainly don't have that as an explicit requirement.
Correct. Correct.
Okay. We do have a house rule that we've adopted. That I think helped me get much more, comfortable when I thought about this. It seemed on its face obvious error. Then I went through what did we adopt, and I felt that the three criteria were met. I'm hesitant to have this rolled over because I think for the integrity of the sports wagering landscape, we should be able to make this decision today. We've had this memorandum now for a few weeks, and that the items weren't requested before. I don't mean to be pushy, but I am trying to preserve our meetings, and kicking it to the next meeting just,
Well, that's, I made myself clear, Madam Chair, and one of the concerns I had when we drafted the reg was also, I didn't want this idea of we made a pricing mistake being an obvious error that would then just necessarily be wiped out, because in that case, it's a very simple process. So I obviously take this interpretation differently. There's 5 of us. If someone wants to move in second, then
I agree with you. Of course, Commissioner O'Brien, it's a matter of 5 of us, yeah.
I guess I just want to just move in second and vote accordingly. That's fine with me.
Yeah. So the 3 items, so the third item was what again? What was your third request?
It was indemnification. It was the status
of
the
fairness,
and then it was the fundamental fairness to the patrons, correct? Or equal treatment.
So commissioners, do we roll it over to December 14th or do we act today? Commissioner Maynard?
Yeah, Madam Chair, I'm more comfortable with the squeaky wheel getting the grease than Commissioner O'Brien is. That said, I'm still interested in the information. And then further, I just wonder if this doesn't hit other parts of Massachusetts law on consumer protections. And maybe we did just miss it when we put together regulations. I don't know. The odds of me voting on this today are lower than a healthy LeBron James scoring less than 8 points in a game. So I'm not going to vote on it without this information.
Okay, and Commissioner Skinner, you feel the same way? Then we won't move on it.
Yeah, I want to respect my fellow commissioners' desire to be fully informed before taking a vote on this. And respectfully, we did have this memo for a couple of weeks, but this is the first opportunity we've had as a commission to discuss the request. And so, going forward, I'm happy through our sports wagering division to seek additional information. But when we're talking about information that has to come from the operator, I'm not sure that's feasible. But, I hear you, Madam Chair, and we'll make some adjustments going forward in that regard.
Well, I'm only saying it not because, I living these public meetings and this is how we do our business, but to the extent it can help our sports wagering team to anticipate any of the types of things, which are all fair requests. Just if it's going to be a request for information that all 5 of us aren't asking for, but one is, then, I agree. I always love more information, Commissioner O'Brien. I'm worried about the jurisdiction piece. We could make that ask ourselves. And that's quite a bit of work, but we could figure that out. Which jurisdictions?
Well, I'm sure the raw numbers are one thing.
Oh, sorry.
And then
sorry.
the individual jurisdictions, if they can be great, but the raw data in and of itself wouldn't be something I would think that's
I get it.
secret.
Sorry, if you're Chair Jardstein, if you were going back to the question of the status of other jurisdictions, I think we can provide that to you very quickly, just because, and we have actually to other states. It's just because it's not currently public information as far as I know. I'm hesitant to provide this for it, but I have the information on hand And I think I
The
can get.
problem is how does it get to the five of us to make our decision if it's protected?
Yeah,
That's,
I understand.
that's where we're caught. It's a dilemma where, if anyone's listening, the legislature, we could have a little relief on this piece. It would be very, very helpful because we're actually right now caught in kind of a conundrum, to borrow Commissioner O'Brien's one of her favorite words. We want that information, but we can't present it publicly. We can get it all privately, but then we can't talk about it. So it's a little dilemma.
And if I could just add to that dilemma, as far as indemnification materials go, I'm not off the top of my head as we sit here, sure under what theory we would be able to withhold that information. So I think it should be assumed if we receive that, that will be public information.
Right. So if it comes into us before you send anything, Jake, you know, it becomes a public record, and we want, we know that you've all been briefed on this. It is a hard, it's just a rule we want to remind folks of. So I'd reach out to our legal team and the sports team before you send anything. Because once it's in our custody, it's up.
No, I understand that. It's just there's a difference between if we're allowed to, quickly go expedient legal review internally before we provide something which we know may well become public. That's different than me talking off the cuff, conversation like this without going through the proper internal process.
Andrew, are you concerned about this going until December 14th? Is this something that we should add on to our Monday, the 20th? Would we be able to get all of this done by the 20th?
Madam Chair, can I speak to that? I'm concerned with people's funds being tied up an extra 2 weeks, for what they bet. And that's my concern with it. These people don't have access to their money. It's already been since October. So that would be my concern.
That's fine. That's been my concern, is the sense of urgency that I thought accompanied this. Maybe that wasn't clear.
Yeah. But if we could get it on for Monday, we could probably get you the information that you requested by then.
And so what would happen is there would be a release of the wages for that.
You're talking about this Monday?
Well, I want, and then Commissioner Maynard,
I'm not able to make a particular meeting on this on Monday, and I will be none too happy if I can't make a decision on this. And so if we have to make a decision on this right now, I'll take a vote, but it's going to be to give the consumers of Massachusetts their money. That's what my vote's going to be.
I'm sort of in the same spot, so.
I'm sorry that I forgot that you weren't going to be. I mean, I'm just looking for solves. I'm looking for solves.
I can do after 1:30 or 2 on Monday, but I cannot do 10:30 or 11 on Monday.
I was just thinking our agenda setting meeting. All right. And you know how many patrons in Massachusetts were affected?
Total number of customers, I believe, were 137.
Thank you.
Memo. And to Bruce's point, we have received, I don't have the exact number offhand, but we have received a handful of customer disputes, maybe 5 to 10.
Okay. Mr. List, thank you for your time today. Commissioner Hill, I think that a motion would be defeated, it sounds like, perhaps. I don't know, given that there's outstanding information that folks want to hear.
I feel like Commissioner Skinner does, that if my fellow commissioners need some questions to be answered, we should get those questions answered before we take a vote. And I'm okay with that.
And it would be after the Thanksgiving holiday, so November, we could not roll it over to December 14th, we'd roll it over to November 30th. That would make sense?
I can do Monday. I just can't do the meeting on Monday. I can do later on Monday. Just want to be clear.
Yeah, I mean, it's also, what, $4,000 in bets?
Correct, 4,000.
DraftKings could just decide to refund customers too, while we work out the first time we've had this come in front of us. It's not, I want to resolve it, but this is the first time this is actually come in front of us, this reg, Madam Chair.
We have a regulation in place, there are house rules in place. Let's get your questions answered the best they can be answered, Commissioner O'Brien, and not perhaps impose a mandate that I don't see a regulation supporting.
I'm not saying
that
that's
would be my
mandate, but I'm
position.
saying your point about the number of customers, I want to point out the
No.
monetary amount too, so.
Yeah. Well, and I'm putting in the context of that third criteria again. You know, I'm hoping that we can stay, be allegiant to the regulations that we've passed, and that include being allegiant to the house, you know, house rules that we as a commission have to pass and approve. I mean, so I'd rather not just do some one-offs right now without. If the further information will give you some level of comfort or get us to a majority vote, I'm, you know, fine. Commissioner Maynard.
If it's of any, I guess if it's of any comfort, I think we will be able to provide the additional information you've requested to extremely quickly. Most of the difficulty with customers having pending bets happens immediately. So if it continues on for a couple of weeks, it's not the end of the world. I would say lastly, I think it is to our understanding, this isn't the first time this has come up before. We did review, I think there was an error request from Barstool earlier in the year. I'm not saying in any way their request is analogous to ours, but certainly we did review that before this meeting.
Yeah, it was a very different factual request, but that's great that we can get the information quickly.
Commissioner, should we try to do it in the afternoon at the time that I know that Commissioner Maynard is taking that day off, so I don't want to impose on him. But do we want to try to do that on November 20th for the benefit of consumers in Massachusetts?
If Commissioner Maynard is okay with that, that would be fine with me.
Commissioner Maynard?
Yeah, let me get you a time right now, which I don't recall happening a lot of times in public meetings, but I'll do it.
You know what? Let's roll it over to November 30th. Thank you, everyone. Thank you, Mr. Lowe.
No, I prefer not to.
No,
do it.
we're
I would
excellent.
prefer not to do that.
You know what? I want to respect your time and your time off.
No, I actually land at back into Massachusetts at 1:05. I am happy to do it anytime after. I can get to the office by 2.
Just one more wrinkle, not to keep being the skunk at the garden party here, but we'd have to post a meeting notice 48 hours in advance, so we're up against that already.
We can do it at 3. It's 2:56.
I can't post that. I'm sorry.
Can't post that
I
fast.
can't get an agenda done in 3 minutes from my desk.
Yeah.
All right. I could get, because we have another proceeding that I can't get that done unless somebody from legal puts it together for me. And it could be, you know, 4:30, but you know what, I didn't realize Commissioner Maynard would actually be back in Massachusetts as opposed to on vacation. I forgot that. Commissioners, I just need some guidance. November 30th?
Fine.
Okay, we'll do, we'll add it to the agenda on November 30th. Mr. List, thank you very much. Appreciate it. Okay. I'm going to turn now to, again, and also Andrew, I didn't mean to, and Bruce, thank you very much for your good work. I'm sorry that we couldn't get everything tidy for you today. My apologies for not managing the meeting in a little bit smoother process. Thank you very much.
Thank you, Chair.
Let's go to item number 6.
Excuse me, Madam Chair, might I just ask about timing for the adjudicatory hearing? we've let the parties know that it's not likely to start at 3, but I'm wondering if we can give any additional information about start time.
We have, we also had an executive session that's important to the commission. I know Commissioner Hill, you wanted to hear from on that matter yesterday, a few weeks ago. So I hate to roll that over. We have Plainridge Park Casino waiting in the wings, as is Encore Boston Harbor to do their reports. Each takes about 20 minutes. And then we have a very short guidelines and grant amounts, which require a vote. The REIT, is there, Caitlin, any flexibility on their schedules?
Well, I know we have on our schedule, it's scheduled 3 to 4, and then probably through the end of the day internally for staff. I can reach out and see if the parties are available through 5.
Chair and Caitlin, if it helps, I have spoken with Attorney Nozzle, and they are aware that the REIT may be bumped to later, but if there is kind of any more input on the specific timing, that would be great.
I would have no problem moving that particular issue, Madam Chair.
Okay, Heather, so that means for item number 7, we would move that to a later date if that works for the other commissioners.
Actually, I'm sorry, I was speaking about the REIT.
No. We're trying to find time in our day. And you said, I'm sorry, what did you say, Heather? Maybe I misinterpreted you.
I had spoken to Attorney Nozzle about the fact that the REIT was going to be moved later. But that said, if the commission wishes to move the item number 7 as well, then we can certainly have communications with MGM about that.
I'm trying to find some time to get the 2 presentations done, Attorney Hall, and also be aware of the fact that the end of the day is approaching for staff. So that helps us by rolling 7 over to a future date, whether it's the 30th or the 14th.
Yeah, and Chair, just so you know that they are amenable to that. I just communicated with Attorney Madama. So thank you.
I figure they might be. That's good. And then we have item number 6, where we have 2 reports, which I think we should have the quarterly reports done. Joe, that brings us to the 2 items 6C and D, which we do need to vote on today. My suggestion is that we move on those 2 items first. I'm going to turn to Commissioner Hill, who would like to start the discussion on item 6C. I want to first, before we do, thank Joe's team on all of the work that has gone into this new process for producing these guidelines and for producing the allocations for across the board. We have had I just want to thank you and Mary. I don't know if I see Mary, but Lily, Mary, and Joe, thank you so much. Commissioner Hill, would you like to take center stage here?
I would be more than happy to. Joe, you mentioned during our agenda setting meeting that we should be able to get this done in 11 seconds. I'm going to ask that we try and do this in 30 seconds. We have seen the proposal quite a few times. We've come to a consensus on what you have proposed. And I think, Madam Chair, unless there's any objection, that I would move that the commission approve the FY 2025 Community Mitigation Fund guidelines as included in the commissioner's packet and discussed here today.
Second. Any further discussion? Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
And Commissioner Maynard.
Aye.
And I vote yes. Okay.
Madam Chair.
Yes, please.
I would move that the commission approve the FY 2025 Community Mitigation Fund grant amounts as included in the commissioner's packet and discussed here today.
Second.
Any further discussion? My one point, we now have Mary. So Mary, thank you. Thank you for all your good work, Lily and Joe. I've got a second. Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
Commissioner Maynard.
Aye.
And I vote yes, 5-0.
That was almost
Okay.
30 seconds.
Well, thank you very much on that. And Madam Chair, if you would just indulge me for a moment. I did want to extend my thanks out to Mary and Lily. This was really a lot of work. We took a program and completely transformed it into something else. And it wasn't just internally, the local community mitigation advisory committees, the subcommittee. We had meetings with stakeholders. We had a public hearing. We got lots of input from lots of people. And I think it was just it was a great process. And it was a lot of work and a lot of hard work by a lot of people and the commission as well. You indulged me a number of times so that I could keep you up to date on what we were doing, and we kind of took it like baby steps a little bit, but I think in the end, I think it certainly has paid off, and they say the proof of the pudding is in the tasting. We will see how that goes in January once it's rolled out and we get our applications in. But thank you all, and thanks to the team.
Very nicely said, Joe, and we express our gratitude. You've just done excellent work, and it is a big change, and I think we'll test it. And it's a process that's been so participatory and transparent, and that's why we're very hopeful it's going to be very, very successful. So thank you. Okay.
Okay, so the next item we have up 6A is the Plainridge Park Casino third quarter report. And so we have with us North Brownsville, Heidi Yates Akbaba, and Kathy Lucas from PPC. And with that, I will turn it right over to them to get started.
Good afternoon, Madam Chair, and good afternoon, Commissioners. Plainridge Park is pleased to present our Q3 2023 update. I'm joined today, as Joe mentioned, by our Vice President of Human Resources, Kathy Lucas. Our Vice President of Finance, Heidi Yates Akbaba, is enjoying some well-deserved time off. And so I'm going to cover the financial portions that are normally covered by Heidi. So jumping right in, sports wagering revenue at PPC's retail sportsbook was $575,000 in third quarter, resulting in a little over $86,000 in sports wagering taxes. With respect to our gaming revenue and taxes, in Q3, we saw net slot revenues of $40,057,000 and total taxes paid to the Commonwealth just shy of $20 million at $19,628,000. For the lottery sales, and for the quarter, lottery sales were $656,000. Of note, there were two large jackpot amounts in August that were $1 billion plus jackpots, which helped us drive sales in those areas. And now turning to our qualified spend data, we had 58% of our qualified spend was within the Commonwealth. And of that amount, 15% happened within our surrounding communities. With respect to our diverse vendor spend, we exceeded our goals. For Q3, women-owned business met the target at 21%. Minority businesses exceeded the target by about 1%, and veteran businesses also exceeded their target by about 1%. On a year-over-year basis, our total qualified spend was up 21%, and diverse spend was up 25%. Now turning to the compliance side, in Q3 of 2023, PPC prevented a total of 231 guests from entering the gaming establishment. Of that group, 15 were minors, 49 were underage, 167 had expired, invalid, or no identification. We had no underage patrons escorted from the gaming area, and there were no instances of underage gambling and no instances of underage alcohol service. And so with that, I will pass it on to Kathy, who will give you a little bit of information on community relations and our employment numbers. Kathy?
Thank you, North, and good afternoon.
Commissioners, I'll just share briefly some of the information or the data on our employment statuses. We had 462 team members in the quarter, and you'll see where we hit with our numbers. So diversity, we were above the goal along with veterans, still slightly under the women goal, but much better than past quarters. And then slightly under our local goal. We had 63% of our team members at the full-time position and then 37% at part-time. With our sports book, a lot of the numbers kind of stayed the same in Q3. You'll see our diversity at 17%, still no veterans sports book. Women up a little from last quarter, 22%. And then actually that was flat to the same quarter. And then local was up 17% and then full-time 50%. Our supervisors and above, you'll see 13, 5, and 35 for diversity, veterans, and women. And just a couple of things that we had going on throughout the quarter in regards to our development. North delivered an executive development retreat where he took the team out to plan for 2024. We also hosted our town hall. That's North there presenting. We honored our Q2 Aces of Penn, the best of the best. We went outside for the Women's Link Business Networking in conjunction with the Chamber of Commerce. We welcomed a new food and beverage director, Matt Carey, to the team. And then we launched our Emerging Leaders Program for our internal candidates looking to go into management. And we're in the process in Q2 of relaunching Women Leading at Penn. And our 2 ambassadors, Heidi and Jen, will lead the program at the property. We had 2 really great things happen in Q2. First being the opening of the Sportsbook restaurant and bar, plus the relocation of our Sportsbook. We are so appreciative of you being present for the opening, getting to meet Teddy Bruschi, and then also at the ribbon cutting. We also held the Spirit of Mass in Q2, and at that event, we rebranded our patio and we did a fundraiser for the American Cancer Society. So really great things going on in Q2 that were customer facing. And then finally, just some of the partnerships that we had on the nonprofit side. We focused our continued efforts with fundraising and awareness with the American Cancer Society. At our Dueling Pianos event, we hosted a fundraiser for them. We also supported Habitat for Humanity. We supported multiple chambers over the summer with business barbecues and golf tournaments. We did a drive for the Attleboro Animal Shelter, collecting toys and treats and gifts for the little animals that are in the shelter. We had a really good opportunity to be present on one of the floats, or actually one of the fire trucks leading the Rentham 350 Grand Parade. And then we did our recruit military at Gillette Stadium in Foxborough with our commitment to bring veterans in. And with that, I'll turn it back over to North.
Thanks, Kathy. That concludes our presentation, and we're now prepared to take any questions you may have regarding our update.
Commissioners, do you have questions? I think the number's going up on women, Kathy.
Yeah.
That's a good thing.
Q4 should be even better. So hopefully we'll, like those periods where I kept saying, just wait till we open up the restaurant, it's coming back.
I was gonna have the bar going.
Do you want to answer?
Yeah, it's going well. So I mean, we've had a good start to the football season, and so it's been great to have folks in there. It's certainly a hopping place for sure on the weekend, and then big game night. So we're really excited and proud of the space.
Good.
Very well done.
Madam Chair?
Yeah. Yes, Commissioner.
So I've got to ask this, and I'm asking all the operators. I'm still not seeing great numbers when it comes to hiring our veterans. Any idea why? I know you guys have reached out to organizations and I know you're trying, but every every update, we still see the number. That's, to me, disappointing. Not your fault for sure, but I'm trying to figure out why.
So Commissioner Hill, with regards to that, we certainly see our numbers right now are at 4%, which hits our target. So I think we've seen some progress in that area. We, do have connections with local veteran groups and have done quite a lot. You'll hear in our next update the support that we've provided to veteran organizations. And I think it's also just about relationships with that group and making sure that they know us, they know that we're here, and know that we're a veteran-friendly organization. So I think with regards to that, it's something that we're always looking at. We occasionally have 2 team members who are veterans, but don't care to disclose that status to us. So we're cognizant of that as well.
Thank you, North, and thank you, Madam Chair.
Anything else, commissioners? All right. It was nice to see you recently, Kathy, and thank you, North.
Thank you.
Kathy does have a lovely office.
It's a lot of
Very
pink going on.
A lot of pink, yeah. All right. Thank you so much.
Thank you. Have a good day.
Thanks, Joe. All set?
Yeah, so next up, Madam Chair and Commissioners, we have Encore Boston Harbor, their third quarter report. And we're joined by Jackie Crum, Juliana Catanzariti, and Carla Pavero. And with that, I will turn it over to Jackie.
So good afternoon, Madam Chair and Commissioners O'Brien, Skinner, Hill, and Maynard. I'm going to turn this over to Juliana, and she can get started with our presentation. I know that everyone's short on time.
Sure, so I'm just going to
No
share
rush. No rush. No. Go ahead, Juliana.
Everyone's able to see that?
Yes.
Now, perfect.
Good afternoon, Madam Chair, Commissioners. Thank you so much for taking the time to go through our quarterly report with us. I know your schedule is packed, so we won't be super long today. So beginning with gaming revenue, taxes, and lottery sales. During Q3, EBH had a gross gaming revenue for table games of about $78 million and a gross gaming revenue for slots of about $104 million. This resulted in a total gross gaming revenue of about $182 million and about $46 million in state taxes were collected. Here's the year-over-year comparison and then the 2023 totals to date. For sports wagering revenue during Q3, we had a total monthly win of about $552,000, and the Commonwealth collected about $78,000 in state retail taxes. During Q3, we had lottery sales of over $1.5 million, and that was a 72% increase over the same quarter of 2022. And here are the year-over-year comparison for that and also the 2023 totals to date. So moving over to workforce, at the end of Q3, we had a total of 3,491 employees unrelated to sports wagering. So 60% of those employees self-identified as belonging to a minority group, 2% were veterans, and 45% were women. Joe mentioned that our Director of Training and Investigations, Carla Pivro, is joining us today, and she will shortly discuss our efforts to hire women in her department and some of the challenges that her team faces. So more to come on that. So here we also
oh, go ahead, Juliana.
So here we have the statistics for non-sports wagering related supervisors and above. Jackie's going to jump in and go through a recent discrepancy in our reporting that we discovered, and we just wanted to elaborate a little bit on that.
So as I believe most of you are aware, RSM is in the process of conducting a diversity audit on all of our numbers. And during a call that we had with our employment team last week, we identified a mistake in the formula that has been used to calculate the percentage of minorities that we report for managers and supervisors and above. Essentially, what we did was we included employees that were categorized as unspecified or who didn't provide any detail about their race or in our minority count. So to be clear, the non-specified individuals were not counted as minorities in the total count. So this was not, it doesn't impact our total count, but it does impact the manager and supervisors and above. So we've remedied the error and wanted to provide you with an accurate calculation. So approximately 595, or about 17% of our employees, do not specify. Please note that this report assumes that none of the employees who are quote unquote unspecified are minorities. For example, if we deducted the 595 from the total amount of employees and ran the same analysis, our percentage of total employees would go up to 83%. Total number of minority employees would go up to 83%. So for manager and above, the number of minority employees is reduced from 89 to 77, and the corrected percentage is reduced from 43 to 37%. For supervisors and above, the number of minority employees is reduced from 327 to 277, and the corrected percentage is reduced from 60 to 50%. And as I said, the total number and percentages were not impacted in that original slide, which Juliana went over for the total number of employees. So going forward, we will obviously make the corrections that need to be made. And we will also provide additional clarity around how these percentages are calculated.
Madam Chair, I have a question.
Sure, Commissioner Skinner.
Hi, Jackie. I apologize, I'm not able to be on camera. I'm having some technical difficulties here on this end with my Wi-Fi. But so I'm gonna need some time to, I guess, digest.
Process.
Do on this. Has this been reported?
Sorry?
Commissioner Skinner, we can't hear you. We heard, has this been reported? Commissioner Skinner? We can't hear you. Last word was, I think you said we can't, has this been reported?
Can you hear me now?
Yes.
Yes.
All right, and then in the meantime, I'm going to try to call in. But this is the first, I've been working closely with the team on this and at MGC on the diversity audit conducted by RSM. Has this been reported to RSM just yet? Because I don't think it's made it to this team, the team on this end yet.
It was actually discovered on a call where we were on the same call as RSM, and we were demonstrating how the formulas were created. And so when we went in and we did a deep dive, we discovered this. And so they were right there when we discovered it, and are very much aware of it.
Okay. So yeah, just in my role, working closely with, our group here, I don't have much to offer because, seeing this for the first time is a little, it's just, I feel like I'm caught off guard a little bit, but it's good that you've caught this issue. And I think that we'll have to just have a discussion tomorrow, just in terms of what that means for purposes of the audit and the findings.
Sure, and it absolutely would be reported as part of the audit. I apologize, we couldn't give you more notice. We were actually just rerunning the numbers. We'd obviously turned in our report, so we wanted to make sure though that we raised this issue and we didn't report the wrong numbers today.
Yeah, no apology necessary at all. It's just this is something that would typically be raised in that sort of forum. But it's absolutely appropriate for the full commission to hear this update from you, Jackie. So thank you.
And just some background, because folks may not understand the RSM audit. At one point, there was a news story on questioning whether the commission was getting accurate data from our casino, our licensed casinos. And I know that I went to Chief Delaney because the information this information flows through his work, and with then Director Wells. And I asked for an audit if it's deemed that it would be very hard internally for us to conduct that audit. And then at some point there was an RFP, which at that point I said, I'm not involved in the selection of an audit company, but RSM was selected. And then I, in coordination with Director Wells, asked Commissioner Skinner to really work on this, which we've been very, very appreciative of her work. But that's how, the audit is directed from the Gaming Commission as opposed to through each facility. So, and it's been on our agenda. And so Commissioner Skinner, this will be a good trigger for us to bring it into further light. I also know we do have, we've received through the news at least some update on the impetus too on this matter. And apparently that was resolved as not being a problem. From my perspective, Jackie, today, thank you for, you're benefiting from an audit. Is
Right.
really what happened. So thank you. And Commissioner Skinner, I know you need to be updated on this. But I don't, I don't think there's plenty of time for you, Commissioner, to get caught up. And I'm sorry that you felt blindsided. I don't think any of us were aware of this. So, but today we are. So thank you, Jackie. Any further questions on this slide? And then Commissioner Skinner and team will work with EBH on it. Okay.
So here are the same numbers for sports wagering related employees. These were not impacted at all by the mistake caught by the audit, so they're the same numbers that they would have been before. So at the end of Q3, there were a total of 21 employees related to sports wagering. 29% self-identified as belonging to a minority group, and 38% were women. Unfortunately, we did not have any sports wager related employees who were veterans, but we continue to recruit veterans for all positions property-wide. In the next slide or so, I'm going to highlight some of those recruitment efforts specifically. So here we also have the supervisory and above breakdown for sports wagering employees. So granted, we're dealing on a much smaller scale here, but 100% of our managers and above self-identified as being minorities, and 50% were women. So here's just a short update on our recruiting efforts. So during Q3, our recruitment team attended or hosted 27 recruiting events. 15% of these events were veteran focused, and of that 15% veteran focused, 3% were specifically focused on women veterans. 11% of the events that our team attended were specifically related to college hospitality programs. And this is important from a female recruiting perspective because 66% of those enrolled in hospitality programs nationwide are women, and that number is even higher locally. So because a majority of these enrollees are women, these events naturally recruit more women. So moving on to operating spend, our discretionary spend for Q3 was about $21 million. 12% of that was spent with minority business enterprises, 5% with veterans business enterprises, and 12% with women's business enterprises. As for the local breakdown, to highlight a few communities, about $1.75 million was spent with businesses in Boston, 2.1 with businesses in Everett, and nearly $2 million with businesses in Somerville. So as promised, we'd like to now introduce Carla Pivro. She is our Director of Security and Investigations, and she's going to speak about compliance and also her experiences with recruiting women for her department.
Good afternoon, Madam Chair. Good afternoon, Commissioners. Thank you for the opportunity to speak. So for the third quarter minor report for us, we had 12 minors total found on the gaming floor and 0 in the sports wagering area. Of the 12, there were 3 that had gamed. Of the 3 that gamed, 1 accessed the gaming floor with another's ID, so an ID swap, and that was discovered when he won a jackpot, was unable to identify himself properly. 2 were the result of security officer error. 1, an ID was not requested, and the other, an ID was requested and failed the Veridoc scan, but however, the officer allowed entry. There were 2 minors under the age of 18, 14 and 17 that did not game or consume alcohol, but accessed the gaming floor for 1 minute. The longest time on the floor, we had actually 2 instances that bumped up our average this month. They were kind of offshoots. The 118 minute was the ID swap that resulted in the jackpot winning, and that was gaming only and no alcohol. And opposite to that, we had the 113 minute span which was a woman that used her sister's ID multiple times over multiple days and did not game, just consumed alcohol. Over the quarter, we caught 17 fake IDs, scanned 246,000, over 246,000 IDs in Veridox for the 12 minors. We will continue to address and stress the importance of paying attention to detail and picking up on those IDs that fail the scan, and also following up on those minors that are denied access at one entrance and then sort of pop up again at another entrance. One even, was with his dad, went into the bathroom, changed his shirt, tried a different entrance with a fake ID that failed, but the officer unfortunately let him on. So that's
Carla, I'm sure
that.
Commissioners are going to be interested in finding out what the follow-up was with respect to that officer.
With which?
The officer who will have him let the minor on.
They're disciplined. They take corrective action.
So we have a progressive discipline policy, and so they are disciplined under that policy. So
further training, right?
Yes, but the first offense would, they get a written notice, and then, if we saw a pattern, that would obviously be extreme, so we could move right to termination. But typically, it's a first notice, a second notice, and then they are terminated.
Commissioners?
Carla, this is Eileen. Good to see you.
Good to see you.
Thank you for going into the detail. I usually ask about the longest on the floor. The long stretch where the woman came back repeatedly with the sister's ID, you talk about attention to detail. What is it that you got? First, my question is, did she really look that much like her sister? Or was this really a question of one or more really not looking at the face?
This particular ID swap, she did look very much like the sister. And the attention to detail more for me is that security officer seeing that failed ID, so the technology's working, and just sort of reacting quick enough to stop that person from accessing the floor.
Right. Okay. Thanks.
Sure.
Any further questions, commissioners? Okay.
Carla, do you want to speak? Sorry, go ahead.
No, I just said thank you.
Okay. Carla, do you want to just speak briefly? I know that you've worked very hard to recruit women in your team, and do you want to speak briefly about those efforts and additional things that you've thought about?
Sure. So what we're seeing now, I think, is sort of an across the board thing, and it's not unsimilar to my past life in law enforcement and women in law enforcement and the challenges to recruiting them. I think we typically face the nature of the work alone as a challenge. I think it's we're very upfront with security officers that are potential hires that they're going to be working overnight for at least one or two bids, which could be 3 to 6 months minimum. And a lot of people, a lot of women just really that isn't for them, and then you sort of take into account the nature of the work itself as far as the conduct of some of our guests that they're likely to encounter, especially on those overnight shifts. So it's sort of a combination of those things and weighing it out. But we continue to sort of showcase, potential hires and pulling in the college recruits that we want them to understand that the skill set that they develop in coming here, into this department, communication, emotional intelligence, their ability to de-escalate and all these things can really professionally, help them grow and develop and be a great, segue into other areas and on property, other departments, which we do have people that transfer to other departments and table games once they're in security for some time, and other careers. And I think it's a matter of a desire to serve as well. I think that individual definitely has to have something in them that wants them to come and help people and serve people. So those are the challenges, but we're going to keep working at it, and we're going to get some more females on board for sure.
Thanks, Carla, for joining us. You filled in really well for Tom Coffey, who actually is in Las Vegas right now. He's working on the, he's helping the team there with Formula One.
Yep. Thank you for having me.
Thanks, Carla.
Okay. So our Day in the Life program happens about twice a year, and it's a program which pairs leaders with team members in the department, and the team member actually trains the leader to perform a 2 to 4 hour shift in their department. So our leaders learn how housekeepers consistently maintain such high levels of cleanliness in our hotel rooms, how our team members in the staff cafe provide meals for over 3,500 team members each day, and how our horticulture team maintains all the floral and plant life throughout the building. For the second year in a row, we ran an employee engagement survey. We had 73% of our employees respond to the survey, which was really what we were aiming for. And we've been working on a department by department basis to review the results and develop action plans. The good news is 84% of our employees say they are proud to work at our company, and 81% say they will recognize Encore Boston Harbor as a great place to work. As we get more of these results compiled, we can give you a more fulsome presentation. Next, yeah. As you know, September was Responsible Gaming Education Month. Our mission was to continue to educate our team members throughout the building about the signs of problem gambling, how to direct guests or other team members to seek assistance. I'd like to thank our Game Sense advisors for working very closely with our team, as always, to grow awareness. So we are incredibly proud to welcome Chef Megan Vaughn as the executive chef of both Rare and Rare Lounge. As you may be aware, this is not typically a female-dominated position, particularly at this level. And we were absolutely thrilled that she agreed to join us. She comes to us from Seattle, and she's really made a lot of great changes in the menus. And I invite everyone to come taste her food.
Jackie.
I'm sorry, not you.
Sorry, but to the public, right?
To the public,
you can
yes.
only imagine.
Yes. Also in September, we participated in ABCD Hoop Dreams to support youth programs. Unfortunately, our team was not excellent and we did not make it to round 2, but we are ready in training for next year. Just a quick overview on our community relations. We're currently at over 4,000 volunteer hours. We've also donated more than 1,300 school supplies to the Everett Public School District, and 1,220 pounds of food to Bread of Life. We packed just under 500,000 meals through our Feed the Funnel event in partnership with the Pack Shack. And we were joined by cheerleaders from New England's favorite football team, as well as their mascot, Pats. We are kicking off another round of Feed the Funnel the week after Thanksgiving. We're aiming to hit, and we're going to hit 1 million meals. And we'd very much welcome any volunteers from the public, maybe the commission. Game Sense can attest to how much fun it is. You can even keep the festive hats if you would like. And at the end of September, we hosted our second annual nonprofit leadership retreat, where nonprofit leaders learn from various guest speakers. We had about 75 attendees from 39 different nonprofits. We started with a diversity and inclusion panel. Jenny gave a great presentation about how to move up through the leadership chain in an organization, both a private organization as well as a nonprofit organization, and the various skills that are needed at different levels. I was fortunate enough to host a philanthropy panel with our partner Ed Kane from Big Night Entertainment Group, Josh Kraft, the president of the New England Patriots Foundation, and Sharon McNally, the chief executive officer of Camp Harborview and the chief of staff for the Connors Family Office. And just a quick update on the TRU patron charitable contributions. As you can see, we added some new organizations, including South Cove Manor at Quincy Point Rehab Center, New England Center for Homeless Veterans, Big Sister Association of Greater Boston, and Animal Rescue League of Boston. I believe that is it. We appreciate the opportunity to present to you today. Please let us know if you have any questions.
Questions for Jackie and the team, commissioners? Jackie, when I was preparing the other night, something came over me and I knew I would see Sharon McNally's name there. A dear friend and really a star. So
She really is. And she had so much good advice for all the other nonprofits. There were a lot of younger people participating in the program, and they were really looking for that input from more seasoned veterans of the nonprofit world.
Well, she's a good one. Thank you. All right. No questions. Commissioners, thank you so much. And thank you for the efforts that are underway to correct the diversity numbers. Appreciate it very much. All right. It is 3:38, commissioners, and I believe that we have gotten through our extensive agenda almost. With respect to item 7, we're going to roll that over to November 30th. Appreciate MGM's flexibility and our GE's. With that, O'Brien, you wanted to give an update.
Yeah, just two things based on feels like a long time ago. When we opened the meeting this morning, you made certain comments about the legalities of the sites. We had talked early on about looking into whether or not we wanted to have some sort of logo or insignia that would go on the mobile apps in particular to let people know you're on a legal site. I do think we need to put that on the agenda for discussion again, because I think it bolsters the statement that you made.
Yes, thank you. And that's that seal of approval. And let's look at that. Thank you, on Monday.
And then the only other one also was there's, been a couple of different companies in the news crossing paths with daily fantasy sports and or looking like they might be iCasinos. And I know I've had some communications with staff on that. I do think we might benefit from getting that marked up sooner rather than later to know some of the companies that have been out there and subjected to certain action, either by attorneys general or other gaming commissions. I do think I'd like to get that out there too.
Yeah, follow up to that. I do think that the past executive director received an inquiry from the operators, our licensed operators. Look into that. I think that's on interim executive director Grossman's desk. We know too that the Attorney General's office has expressed interest in working on this matter, and so we really want to coordinate efforts. And so, in terms of what it will be marked up, let's give that some thought. But we've got till Monday.
Yeah,
thank
at
you.
a minimum, I would like it to be on the under review to sort of make sure we push it up.
Really good idea. Thank you. And Commissioner O'Brien, good reminder. And thanks, Trudy just came on board. So a couple more items for us for Wednesday and Monday, Wednesday. Okay. Thanks so much. All right. With that said, anything else? Any other business, commissioners?
I have an update, Madam Chair. I thank you, Commissioner O'Brien, for raising that issue that is under review sort of jointly with the commission and the Attorney General's office. I had a few discussions with Todd just in terms of the appropriateness of putting that under review. So I'm glad it's kind of been decided at this point. By way of just an update, I wanted to let you all know that the IAB director position is posted now. We are still in the process, our HR is still in the process of expanding that posting to some of the affinity associations, some of the public safety and law enforcement associations. So that is an ongoing process, and we are working very diligently and quickly to get that position just sort of distributed as widely as possible. So more to come on sort of the process that the subcommittee will undertake to review any resumes that we receive. So we can, I think the item is already under review on our agenda setting schedule, but that's all I have on that for now.
Commissioner Hill, anything you want to add? You gave a thumbs up, Commissioner Skinner. All right. Thank you very much for that update. Anything else, commissioners? All right, before we have a motion to adjourn, we do have our adjudicatory hearing. I need a break. I don't know if you do, but it's 3:45. 4 o'clock. Is that too much time? Is that okay?
That's just fine.
That's okay.
I got a thumbs up from Heather. That's good. Is that okay? Thanks. All right, well, I'm honestly, right now, I cannot remember how, we have a different link to go into, but it is a public meeting. We preserve the right to go private when necessary. Okay.
Okay,
Thanks,
so
everyone.
move to adjourn this one.
Thank you
Second.
so much.
Second.
Thank you so much, Commissioner Hill. Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
And Commissioner Maynard.
Aye.
And I vote yes, 5-0 to everybody. Excellent, excellent work. Thank you. A long meeting, a lot done.